supply and housing delivery test position. As has been made clear, the authority is not suggesting that the harm to the significance of the heritage assets outweighs the public benefits that would arise, and has, of course, withdrawn reason for refusal too. Nonetheless, that harm does also, and importantly, weigh in the planning balance against the proposals. So against that very brief overview, these submissions now address, firstly, the impact on the national landscape, then the mixed use issue, and then I address you, sir, on the planning balance. So turning first, if I may, to the effect on the Cotswolds national landscape, that's of course is main issue one. Can I start by just highlighting the policy position? I know it's familiar, but it is important, sir. All the policies applicable to the national landscape point to one very important matter in this case. That is that the allocation of around 300 dwellings is of real importance. It was based on an informed and properly based assessment of the likely impacts by the council and the core strategy inspector, despite the appellant's attempt to undermine this by reference to the 300 not being a cap and by suggesting it was broad brush. The impression arising from Mr. Frampton's evidence, before cross-examination certainly, I would say, sir, was that the 300 was rather irrelevant and certainly of little importance. So, however, the real importance of the around 300 is reflected in placemaking principle 5 of the policy. The landscape requirements of which I'm not going to read them out, you're familiar with, are there for your reference and hope ease of reading, but you'll know, just highlight a couple of points. That's the protect the tree belt on the southern edge, to the bottom of my page 2, to ensure screening of the site from views to the south, and you'll know the avoid or minimise detrimental impacts on the Cotswolds and related matters. So I'll take those if that's acceptable as read. There is agreement that the development plan, including policy B3A, which is considered to be the most important local plan policy for determining the appeal, is up to date. Mr. Frampton's evidence confirmed that the appellant is not alleging any conflict between B3A and the current planning policy framework. That is even though the government and the new framework place added emphasis on meeting housing need and includes mandatory housing requirements, which of course the appellant heavily relies upon. So the appellant's reliance on the efficient use of land, as important as that is in itself, in the circumstances, hollow. It is clearly should not override the meeting of policy B3A and the planning placemaking principles of that, and in particular that relating to the national landscape, highlighted above, given the policies and legislation underpinning the importance of those landscapes. In any event, the making of effective use of land in part 11 of the framework is expressly subject to safeguarding and improving the environment, which, as Mr. Frampton agreed when I asked him questions, is addressed in part 15 of the framework in respect of national landscapes, and in particular, so you'll be familiar with our references to paragraphs 189 and 190. And even within paragraph 130C, which Mr. Frampton specifically referred to, it qualifies the advice to refuse applications failing to make efficient use of land with the need to take into account the policies in the framework. It does not override the application of the national landscape policies. The debate about whether the additional words added to what is now paragraph 189 of the framework, and that's in terms, you'll recall, of limiting the scale and extent of development, should be limited, are new or just emphasis, is of little, if any, consequence. The fact is that they are now there, and Mr. Frampton recognised that the framework seeks to limit the scale of extent and development in those landscapes. So further, and consistent with the adverse case, for major development, the approach in the framework, paragraph 190, of course applies. However, policy B3A itself requires that development avoids or minimises impact on the landscape, and it is agreed there is no conflict of that with the national planning policy framework. So the authority's stance on the policy approach is, with respect, on solid ground. And so that ground has in fact been reinforced since the original allocation in the 2014 core strategy in the following ways. Firstly, it was only in July 2018 that the express reference to the scale and extent of development being limited was introduced into the framework. Secondly, a year later, in July 2019, the PPG, Planning Practice Guidance, was amended to note that the framework now makes clear that the scale and extent of development in national landscapes should be limited, and I emphasise this, in view of the importance of conserving and enhancing their landscapes and scenic beauty. And the PPG goes on, again for the first time as far as we're aware, to state that this may mean that it is not possible to meet the objectively assessed needs for development through the plan making process. So that was a significant new acknowledgement of the importance of national landscapes. That Mr. Frampton did not consider that second element relevant, if you recall his answers, and didn't even refer to it, further tempers the appellant's reliance on housing need. So thirdly, prior to 2023, authorities, including planning authorities and government departments and other public bodies, merely had to have regard to the statutory purposes of protected landscapes, which include, of course, the national landscapes. However, again, you'd be familiar with this from what's been said at the inquiry, if not before, the amendment to the Section 85 of the Countryside and Rights of Way Act 2000 means that relevant authorities must now seek to further the statutory purposes of those national landscapes. It is not disputed by the appellant that the duty has thereby been strengthened. However, Mr. Frampton has, with respect, failed, we would suggest, to grasp the importance of this change and the potential implications of that. So fourthly, and finally on this, in terms of those changes, the protected landscape guidance makes clear that the duty is intended to facilitate better outcomes for England's protected landscapes. Further, the duty is an active one, and as far as is reasonably practical, relevant authorities should seek to avoid harm and contribute to the conservation and enhancement of the natural beauty, special qualities and key characteristics of protected landscapes. That can't be ignored and has to be read along with the specific reference to development management decisions having to seek to further the purposes of the protected landscape, considering whether such measures can be embedded in the design of plans and proposals where reasonably practical. Excuse me. As explained below, the proposals do not enable the meeting of this duty on all the guidance on the evidence before the inquiry. Harm could be avoided in a practical and feasible way in landscape and visual terms as relevant to conservation enhancement of the national landscape by a proposal in accordance with the allocation of the agreed around 300 dwellings, which would minimise the harm and not just limit the harm that would arise from the proposed up to 290 dwellings for phases 3 and 4, on top, of course, of that arising from the already approved and nearly built 171 for phase 1. So it should be overlooked that the local plan has been updated to further reflect the importance of national landscapes by adding criterion 4 to NE2, and that's affording great weight to conserving and enhancing landscape and scenic beauty of the AOMBs with particular reference to their special qualities. So that's all consistent with this thrust and recognition of the importance of national landscapes. So against that background, can I then turn to the the allocation itself before coming on to look at the implications of the policies for the allocation and its development as proposed? There has been much reference to and discussion of the 300 dwellings not being a cap. As noted above, however, there is no dispute that the allocation is for around 300 dwellings. So Mr. Frampton's criticism of the council going behind the allocation are, we certainly say, wide of the mark. As reason for refusal 1 makes clear, the members were concerned, as they were entitled to be, about the impact of the proposals on the special qualities of the AMB, given that the proposals far exceed the around 300 dwellings. And contrary to what Mr. Frampton implied, the authority is not disputing that the allocation is needed, and it's that allocation. We consider that Mr. Frampton reads far too much into the flexibility intended by the core structure inspector, as Mr. Reynolds has made admirably clear. Firstly, the allocation was clearly based on 300 or so. The assessments were clearly on that basis. And thirdly, that includes the highways assessment, if you recall us referring to that, which was tested for a development of 300 dwellings. And again, I'll give you the reference, as I said I would, there in the footnote. So the paucity of Mr. Frampton's point on this was testified to by his original evidence on the core structure inspector's assessment of the around 300 dwelling allocation to discharge the requirement for exceptional circumstances for a development which should otherwise be refused in accordance with paragraph 190 of the framework. We were somewhat dumbfounded that he could possibly rely upon this and ignore what are the inevitable greater impacts, certainly in landscape and visual terms, of a development which would lead, even without phase 2 being accounted for, to a more than 50% increase over the allocation. And you will recall, sir, the appellant has accepted in the statement of common ground that up to 461 is not around 300. The appellant's arguments are not helped by reliance on the around 300 being in the plan period. Of course it is. That is what allocations as opposed to safeguarded sites are for. If the allocation were for a greater number, but with the around 300 of that to be delivered during the plan period, the policy would of course say so. Moreover, despite the position at the inquiry, Mr. Frampton has previously acknowledged that. He has also effectively acknowledged previously that the allocation of the site for around 300 dwellings is clear and of substance. And that is revealed, and we rely upon, the Frampton's hearing statement for the examination of the partial update plans there in June 2022. They at that stage argued that to make the update plan, partial update, sound, policy 3A should be changed to allow for, and you'll recall this when we did last week, that there should be lifted to around 450 dwellings, but again in the plan period. And then with the same density, and then with the same reference at the end to the figure of 450 not being a cap. So as Mr. Reynolds pointed out, these amendments sought to bring the development in line with what a month earlier had been applied for through the appeal scheme. And as Mr. Reynolds also pointed out, if the appellant was comfortable that the appeal proposals were consistent with the terms of policy B3A, they would not have troubled to put forward and contend for this change. This change was, of course, not accepted by the authority or the examining inspectors. Forgive me, my computer's playing out. This change was not accepted, sir, by the LPA or the examining inspector. No wonder the appellant complains about reference to the evolution of the plans. That's the forensic archaeology point, sir. And that's the point you touched upon this morning about that reference to the new authority, which was in the opening, so there's no problem with that. But, sir, this actually undermines much of their arguments. The appellant cannot delve into the plan history themselves when they think fit, as Mr. Frampton did, and they expect the local authority just to lie back and allow an incorrect impression, as we see it, sir, to remain on record. In any event, this is relevant more to the application of the policy rather than its interpretation, which seems agreed. The latter was actually the concern of the courts, the using of this to try and interpret the policy. So, but as things have gone through, well, we would suggest it's more about its application than any differences about the meaning of it. So the appellant, going back to the text, the appellant through Mr. Frampton sought to give the impression that the authority has actively promoted an additional 100 to 150 dwellings on the allocation. And it is fair to say that the reference in the committee report for the phase 1 development might have given that impression, particularly if you read it or read it, as Mr. Frampton wrongly did, as saying that it was likely that a scheme of that larger side would still accord with the core structure development core structure plan development requirements. It actually says, as you may recall, sir, could, as was conceded during the cross-examination of Mr. Frampton. So that is a significant difference, as Mr. Frampton, I believe, accepted when I was asking him. Further, that report was from the 6th of June 2018 and before the significant policy and legal events relating to national landscapes, which I've set out, so if you recall, in paragraph 13 above, including the new statutory power, the statutory duty increase and so on. So Mr. Frampton next relied upon the June 2017 placemaking plan inspector's report, where the inspector referred to the pre-application discussions indicating that it was likely that the capacity would increase by 100 to 150 dwellings. Critically, there was no increase in the allocation, and the local planning authority was not suggesting there should be such a change to the plan. Moreover, to put the matter beyond doubt, in its response to the appellant's attempt to change the update plan to allow for the 450 dwellings in the plan period, which I referred to above, but the authority's response to that, and you will recall this from last week, so the bit I emphasise is it's not appropriate to increase capacity at the odd down site, B3A, as evidence shows this would be too harmful. But the council's position in the development plan process is therefore clear and absolutely clear. There has been no suggestion in any formal development plan related document so the council supporting an increase of the around 300 dwellings to around 400 to 450. Its formal position, consistently held, as far as I'm aware, has been that it would be too harmful, and we respectfully suggest that has been demonstrated through the evidence to this inquiry. Therefore, although the appellant has been, both at the time of the examination of the core strategy and since, seeking a much higher figure than 300, this has not been accepted by any inspector or by the council. And indeed, the core strategy inspector supported the council's assessment underpinning the around 300 dwellings as being reasonable. So can I then turn to the approach to development in the national landscape? And that's just pulling together the threads of the policy and drawing them towards the relevance of this case. So the strict approach to development in a national landscape is clearly set out at paragraphs 189 and 90 of the framework as referred to above. So the policy aspects, I don't repeat them here, save to emphasise that the advice in paragraph 190 is that planning permission for development in the national landscape should be refused for major development other than in exceptional circumstances. It is very clear, should be refused other than in exceptional circumstances. However, as noted in the authority's opening statement, it is important to highlight that the courts have recognised that the real sense of the giving of great weight to the conserving and enhancing natural beauty in national landscapes in the framework is an expectation that the decision will be in favour of the protection of the landscape and scenic beauty of what was then an AONB, of course, or against harm to that interest. And that was the Ticehurst case that I referred to in opening and repeat the citation there for your reference. Further, it has been held that if the Section 85 1A duty is to be performed, the authority will inevitably have to give great weight to conservation and enhancement of the AONB's landscape and scenic beauty. That great weight is capable of being overcome in exceptional circumstances for major development. However, as is now agreed, the approach in paragraph 190 does apply to the appeal proposals, and the allocation cannot be relied upon for that purpose, although, of course, material. So can I just turn then, please, to the exceptional circumstances? And these submissions will now consider whether the evidence supports the appellant's much undermined contention following Mr. Frampton's far-reaching concession that exceptional circumstances do apply. We will first, and that's in, can't rely on the core strategy. We will first deal with 190 CISA, namely relating to the detrimental effect on the environment, the landscape and recreation opportunities, and the extent to which that could be moderated. So, as referred to above, by paragraph 17, the appellant has maintained that exceptional circumstances have already been established by the allocation of the site. That was the position in Mr. Frampton's proof and in the appellant's opening submissions. Mr. Frampton also had even relied upon the officer's report for phase 1, where the officer had said exceptional circumstances need not be demonstrated. So given that that scheme was only for 171 dwellings, that was a completely erroneous contention by Mr. Frampton to rely upon that. So at the 11th hour and 59th minute in his evidence in chief, Mr. Frampton resiled from his position, which permeates much of his evidence. Indeed, his evidence on exceptional circumstances, beyond having relied upon the core strategy allocation, is somewhat scant and unconvincing. As I will return to below, Mr. Frampton has simply, with respect, not reflected the restrictive approach to development in the national landscape and the harm that would result. He has, if I can put it this way, been swept along with optimising use of land and not given proper weight to the layers of significant protection given to national landscapes. And I'll turn then, in that context, sir, to what we would ask you to take on board, along with all the other evidence, in terms of the landscape and visual harm. It is of note that Mr. Frampton's position was that it is difficult to understand what additional harm will arise to the AONB through the detail for the proposed development, which would not otherwise arisen from the development of the allocation in any event. That again betrays, we say, a lack of understanding of the consequences of developing a much larger area of the allocation site, which of course is all within the national landscape, than is required to provide around 300 dwellings at a density of 35 to 40 dwellings per hectare. At an average density of 37.5 dwellings per hectare, 320 dwellings would require about 8.5 hectares. That is significantly less than is proposed to be used, of course, as I discussed when cross-examining Mr. Frampton. And as Mr. Reynolds pointed out, the core strategy inspector stated that the capacity of around 300 dwellings reflects the fact that substantial parts of the allocated area are not suitable for built development. Whilst that number is not a cap, any exceedance depends upon all the placemaking principles being met. Although the appellant's evidence at times gives a different impression, Mr. Frampton did accept under cross-examination that the development in the beige area of the concept plan, outside the area noted as avoid development on this field, still had to comply with all relevant placemaking principles. Indeed, Prescott was not suggesting no development on either phase 3 or phase 4 land, but just that it was much reduced and set back with better screening as well, which seems a very sensible and proportionate approach to achieve the allocation. So as Ms. Prescott has detailed, the proposals will inevitably cause landscape and visual harm beyond that likely to have been anticipated in the core strategy assessment, and in particular intrude into the skyline even more so than for phase 1 development. That itself is a very unfortunate intrusion into the skyline and brings forward the urban development to the edge of Sulis Plateau. The harm could be appreciably reduced by reducing the number of dwellings in phases 3 and 4 to deliver an overall quantum combined with phase 1 closer to the around 300, consistent with placemaking principle 1. So the differences in the assessments are clearly set out in Ms. Prescott's Appendix A. She has, of course, given her view of the appeal proposals, the impact of which she considers the LVIA underestimates, as detailed in that table. You will, of course, rate your own view, so either now or in due course, but I give you the references there we rely on, because she also assesses a more allocation compliant scheme, as you will have seen, of 130 to 150 dwellings in terms of the total number of dwellings combined with phase 1 being around 300. That was found by the core strategy inspector to be moderate harm, but only then on the basis that the harm would be contained largely within the plateau, whereas the appeal proposal would have wider adverse effects. The appellant appeared to suggest at one point, I think it was when Ms. Prescott was being cross-examined, that these differences with Mr. Cale were of small measure. However, they are in fact very important when seeking to give great weight to protection of national landscapes. Moreover, as noted in the LPA's opening statement, the courts have held that the effect of giving great weight, even where to what might otherwise in any case be assessed as a relatively modest degree of harm, might be sufficient as a matter of planning judgment to amount to a reason for refusal, when absent that policy, that might not be the case. So in this case, that applies more so to the clear harm above and beyond that which would arise for the allocation of around 300. Moreover, although the appellant is quite right to say that the local planning authority is not contending that there is any legal flaw in not considering alternative schemes with a lesser number of dwellings, that does not assist the appellant on this issue. You'll recall the scoping opinion, which Ms. Prescott referred to, did actually state under alternative options, made it clear they didn't it wasn't necessary to look at alternative sites because it was an allocated site. But it then says, however, the assessment of alternate design proposals in respect of the evolution of scale, mass and quantum of development on the project site is considered appropriate. Policy B3A requires the avoidance or minimising of harm to the national landscape. It does not say limit. And despite the appellant's attempt at times to contend otherwise, this is not a semantic difference. It is a difference of real and important substance in the circumstances. What in essence has happened is that the scheme proposed is based on the parameter plans with the aim of limiting the impact of that scheme for up to 290 dwellings. Even for those parameter plans, there is, as Mr. Cale agreed, as I understood his evidence, nothing in the documentation before this inquiry underpinning how they were arrived at. Certainly no consideration, you'll know, of alternatives in the way we put it to him. In any event, as Mr. Cale agreed, there were no alternatives considered other than the reduction of the scheme from 300 to 290 dwellings to accommodate the allotments. There has been no consideration by the appellant as to whether and how a lesser scheme could minimise the harm. Most importantly, there has been no assessment by the appellant of the allocation for around 300 dwellings compared to develop what is proposed, leading up to the 461 dwellings, even without phase 2. So there's no comparison provided by the appellant as to how these would compare in terms of compliance with placemaking principle 5. And in shorthand, Mr. Cale has sought to limit and mitigate the impact of the proposals and to minimise impact by assessing a more allocation consistent development. Most of the mitigation measures are of no assistance to the concerns raised by Ms. Prescott. So we also consider that the impacts of the proposals have been underestimated in the landscape and visual impact assessment and by Mr. Cale. One would highlight at this stage the following points. You'll have the whole evidence, but we can highlight the following. Firstly, it is agreed with Mr. Cale that in several of the special qualities of the Cotswold national landscape are relevant to considerations of the impact of the proposals. And I've set those out there, so I don't think I need to highlight those there, so that you'll be clear of them, particularly relating to the escarpment and the distinctive settlements in terms of matters that have come up. Secondly, the management plan for the national landscape policies are agreed to be important, especially given the statutory function of the Cotswold Conservation Board and the aim to conserve and enhance the beauty of the national landscape. These include CE1, which states that the proposal should have regard to and be compatible with and reinforce the landscape character, and that proposals should have regard to the scenic quality of the location and setting and ensure that views, including those into and out of the national landscape and visual amenity, are conserved and enhanced. They also include CE3, which provides that proposals should have regard to and be compatible with and reinforce this local distinctiveness of, for example, settlement patterns and building scale. There are also policies covering tranquility and dark skies. So thirdly, the sensitivity of the national landscape in this locality is also recognised elsewhere. And I took Mr. Cale to do in the first part of his cross-examination. Firstly, the Design West panel, reviewing the proposals in 2022, noted that the site was in a particularly sensitive location with respect to the landscape setting and its location on the edge of a World Heritage City. And the panel went on to say that this is clearly an exceptional site, and the landscape quality of the area is a key aspect of the site's exceptional character. We observed that the ambition and vision expressed for the site as being a high quality residential neighbourhood with high quality and diverse landscape was not fully represented by the documents we examined. And so that latter concern, expressed in the latter part of that quote, was one of the references that Miss Prescott made to the panel's review in her evidence. And I've given you the reference there. So next, fourthly, the Bathscape Landscape Character Assessment, 2017, describes what it considers as the Sulis Plateau being heavily influenced by the urban edge of the city on its northern border, a factor, of course, that the core structure inspector took into account. However, this needs to be seen in the round. Firstly, so it refers to the only settlement within the landscape character areas being South Stoke. That is relevant to Miss Prescott's concern regarding the perceived coalescence of that settlement with the development from certain views in the national landscape. Secondly, the landscape character area assessment refers to the eastern part of the plateau, including phases 3 and 4 land, as Mr. Cale agreed under cross-examination, in terms of its openness, as Miss Prescott emphasised giving her evidence. As Miss Prescott also pointed out, the Cooper Partnership Landscape Assessment and Strategy carried out on behalf of the landowners, that was in 2013 for the core strategy process, that said similarly that the larger eastern part is having a more open character, but still enclosed by woodland as compared to the more enclosed western part. And notwithstanding this, the phase 1 development, as Miss Prescott, as I recall, unchallenged evidence described, is sitting proudly to the west of Sulis Manor, with layers of upper story and roof profiles being prominent in this view over the foreground trees. And thirdly and finally on this, significantly and consistently with the above, it is also stated in the Bathscape character assessment under tranquility that walking within the open fields to the east of Sulis Manor, although close to the urban edge, there is a sense of peaceful countryside. So leading from that, finally on this point, the moderation to the sensitivity that Mr. Cale applied to the site on the basis of the urban context, we say is therefore overstated. Further, the moderation applied for the site allocation is misconceived, as that should only relate to the site allocation of around 300 dwellings in the circumstances. Accordingly, the whole basis of Mr. Cale's moderation is unconvincing, and this is at least in part explains why he has underassessed the impacts compared to Miss Prescott. So Mr. Cale has also actually underplayed the visibility of the appeal proposals, even on the basis of the LVIA from more distant views, as was exposed. He was cross-examined on this. He stated in the proof, you may recall, that the development will be variously just visible above and or through the intervening vegetation in more distant views from the south and north. When taken to the LVIA and reminded that this states that such views, the upper parts of proposed development will be seen on the skyline above existing vegetation along the southern edge of the site, and giving the assessment of those impacts, he agreed that the word just should be deleted from that part of his proof. That is important, sir. And more importantly, he also agreed that in some such views, the development would be clearly visible. Of course it will be. The appellant has tried to play this down by reference to what the orange line on the montage shows, but Mr. Cale knows, of course, what this shows. It represents the highest part of the solid buildings, the rooftops, which will be seen as shown clearly above and between the vegetation, even allowing for growth, spread more widely by about 50%, I think, than even the unfortunate, in this sense, phase 1. That is no doubt why Mr. Cale fairly and correctly accepted that the development would be clearly visible in some such views. Somebody travelling in a car, by foot or on bike in the area to the south of the site would be able to get such views at various points. The unacceptability of this is clearly confirmed by reference to the key qualities of Cotswold national landscape policies, as I have referred to above. That should be sufficient to confirm that the proposals do not minimise the impact on the national landscape as required by policy B3A and sought by the NPPF. And given the importance of this consideration, they clearly do not qualify to exceed the around 300 dwelling allocation. Indeed, they reinforce the importance of and remind us as to why the allocation is for around 300 dwellings. So in addition, Mr. Cale was right to refer to and recognise the importance of the Bath building height strategy. That was in his proof of evidence, as I give you the reference there. For the appellant to try and go behind that in Mr. Frampton's evidence in chief was, with respect, utterly unconvincing. It had the air of evidential panic, quite frankly. Mr. Frampton confirmed under cross-examination that he had read Mr. Cale's proof before he submitted his evidence, and yet he presumably took no point with it at that stage. No doubt as Mr. Cale gave his evidence, it dawned upon the appellant how damaging that evidence was. However, in trying to undermine the strategy, the building height strategy, the appellant has, with respect, missed the point and dug a deeper evidential hole, exposing this critical problem with the proposals. No one ever suggested that the strategy was supplementary planning document or guidance. So that point made by Mr. Frampton in chief on that changes nothing. Mr. Cale nonetheless still recognised its importance in relation to the proposals, and his evidence stands. That is because although only part of the allocation is within Zone 5, I recall that being clarified in the evidence in chief of Mr. Frampton, the text is plainly highly relevant. In particular, Mr. Cale fairly and correctly brought to the inquirer's attention in his proof the following parts of the strategy. Firstly, although some development has occurred on the plateau, says the strategy, due to topography and tree-covered plateau edges, development on plateau is usually not visible in views from locations within the valley, on hill slopes, or even on the plateaus themselves. This reinforces the OUVs and character of Bath as a city contained by the countryside and hidden in a valley. So that remains highly relevant and further highlights the harm that would arise from development that would be perceived as on the plateau edge that would, as the appellant accepts with Mr. Cale, be clearly visible. Next, the existing character of the plateau is of a landscape-dominated environment interspersed with built form. That's what the strategy says. Thirdly, strategy goes on to say new development that would be high enough to be visible above the tree cover or even too close to the edge of the plateau would be detrimental to the OUV and therefore needs to be managed. And although that refers to the OUV, it's not clear why. These matters are obviously clearly closely linked. It is not clear why the appellant is trying to question the relevance of this. It plainly is. And our notes show Mr. Cale accepted that. Fourthly, sir, the stated objectives in the strategy for new development include preventing visual intrusion of development into views from hills and plateau onto the Georgian city and wider Bath setting. And again, that is highly relevant. To put the matter beyond doubt, and this really should put the matter beyond doubt, Mr. Cale specifically set out in his evidence and confirmed under cross-examination that the stated objectives and recommendations of the strategy align in general terms with policy B3A. That was his evidence. So quite what Mr. Frampton was attempting to achieve is difficult to understand. And just to top it all, Mr. Frampton accepted under cross-examination that he was not adding to or altering Mr. Cale's evidence, but relying on it. So however, what matters is that all this just highlights and underscores the flaws in the scheme in this respect. They are flaws that really matter in the sensitive environmental context and the strict policy and legal context that apply. It highlights that the proposals do not minimise the impact in accordance with the allocation. It highlights the consequences of the appellant not having looked at alternative schemes of around 300 dwellings, thus in accordance with the allocation. Somewhat curious that the appellant was so critical of Miss Priscott in referring, you may remember, to map OD3. That was taken from the WHS setting and AOMB LDIA for the land adjoining Odd Down in the core strategy process. That was the red and orange parts on the plan given showing the different implications in terms of intensity of development. Given that it was in the appellant, it was actually in the appellant's updated planning statement. So that is the plan showing the sensitivities for the different parts, as I said, of the allocation, with the high negative parts of phases 3 and 4 being generally applicable to the southern half or southern part. In his rebuttal proof, Mr. Cale pointed out that this has been updated with an indicative line further south than the original division between the high negative and medium negative. And although Ms. Priscott did not refer to this updated position, it is difficult to understand how this actually helps the appellant. Mr. Cale had not, in his original evidence, brought attention to either plan and accepted that the development does go further south than the updated indicative line. He relied upon the updated report being provisional and an indicative best guess. However, sir, this was clearly the product of a proportionate amount of work at that stage. What was also said, it should be noted in the updated report, was that, with my emphasis, it is not possible to specify exactly the acceptable southerly extent of the development. That does not mean it is not informative and material. Given that, it is even more imperative that there was a proper assessment to ensure the impacts were minimised. The further technical work that Mr. Kao relies upon is, in respect, not fit for that purpose, as the evidence has showed. The parameter plans have not been shown to be based on minimising the impact on the national landscape, but of limiting and or mitigating impacts arising from the up to 290 dwelling scheme. That was reinforced by Mr. Kao's evidence in chief when he referred to, asked about, referred to drawing back the vegetation by 14 metres, but that was based on arboricultural and ecological reasons and to contribute drainage features, as I think he accepted when I asked him under cross-examination as well. And it was not related to landscape and visual. That wasn't the genesis of it. The appellant's defence to all this seems to be, at least in part, to rely on Miss Prescott's acceptance under cross-examination that she was not seeking to change the building height parameter plan. Miss Prescott is not the planning witness, of course, but she was right to say that because they are part, an important part, the parameter plans, of the application, as Mr. Reynolds pointed out when he was asked about this under cross-examination. It is also somewhat ironic, given that it was Miss Prescott alone who had considered a more allocation-compliant scheme. Plainly, if the number of dwellings is reduced, the landscape impact will be reduced. Moreover, plainly the intrusion into the skyline can and should be reduced. For even the appellant's landscape witness to accept that this will be clearly visible, given the importance of keeping this predominantly wooded and not unduly impacting on the views of the Sulis Plateau, is, we say, highly damaging of the proposals. Again, the repeated reliance on Miss Prescott accepting that the development does not have to be invisible can't possibly assist the appellant on the evidence. As Mr. Reynolds reminded us, PP5 of policy B3A also requires that additional planting to the south ensures visual screening of the site from the views, and we say that would not be achieved. We may have misunderstood, but there seemed to be a hint at some points that as phase 1 development alters the baseline, this helps justify the impact of phases 3 and 4. That cannot possibly be the correct approach. It really would be extremely unfortunate if the lessons from phase 1 are not learned and put into practice. Mere tinkering with the roof colour, as Mr. Kao proposed will be needed for the appeal proposals even, cannot be the answer. And that itself testifies to the need for going back to the drawing board and following the policy edict properly. And if I can just pause there for one moment, so that takes us back to our debate this morning where we say conditions can't remedy the issues. I'm not going to repeat those, hence my reference to going back to the drawing board. We rely upon what was said this morning and our position there. Can I then just make a few conclusions, brief conclusions on the exceptions criteria in the paragraph 190 of the framework. Accordingly, applying 190C of the framework should lead to the conclusion that exceptional circumstances have not been demonstrated. That is particularly so as there is nothing arising from consideration of factors A and B of paragraph 190, which we say would support any other conclusion. Turning briefly to those other two factors as addressed by Mr. Reynolds, the need for the development is not the same as at the time of the core strategy when there was no 5-year housing land supply and no alternatives. That has changed as detailed in his evidence and summarised in chief. The trajectory then and now, as Mr. Frampton accepted, allows for 300 dwellings arising from the allocation site. The significant increases in the housing requirement will have to be addressed, and there are options which will need to be considered, as again Mr. Reynolds has explained. However, as addressed above and agreed by Mr. Frampton, the framework has in no way watered down the protection to national landscapes, in contrast to the approach to the Greenbelt. So that completes my submissions on that, and I can now turn to my shorter submissions on main issue 3. Firstly, then the planning balance. Main issue 3, so that's the mixed use issue. The allocation under policy B3A, as set out in placemaking principle 1, is of course for residential-led mixed-use development. That requirement for a mixed-use development within policy B1A, B3A, accords with the wider development plan approach and is consistent with the approach in the framework. Providing a mix of uses in new development can help enrich the character and qualities of places in accordance with good design principles. There is not any in principle dispute with the appellant, as I understand it, regarding the validity of those policy objectives themselves. However, there is of course a dispute as to whether the policy requirements are met by the proposals. The policy conflict seems self-evident to us, and the implications of that are, of course, in terms of the overall planning balance, a matter of planning judgment. Reliance on surrounding uses and existing non-residential uses seems unjustified given the clear policy wording as we interpret it. The LPA's position is as follows. Firstly, PP1 placemaking principle 1 requires a residential-led mixed-use development. This is consistent with the local plan policies D1, D3, and with the framework's policy paragraphs 96 and 98 and 139, which promote mixed-use development. Secondly, this, as Mr. Reynolds told the inquiry, is consistent also with other large allocations in the plan. Thirdly, what is proposed is a housing development with consequential pieces of supporting infrastructure, landscaping, open space, drainage, ecological mitigation. You already heard reference to that by Mr. Neal. So much of that and the allotments are separately covered in any event by PP placemaking principle 3, provision of green infrastructure, and if the appellant's contention on this were correct, would render redundant the requirement in placemaking principle 1 for mixed use. Fourthly, Mr. Frampton's contention that the requirement cannot apply to each application for any part of the overall allocation does not assist them. There is no qualifying new non-residential use provided for in the master plan, and none has been provided as part of phase 1. Next, the football club and manor farm are in alternative uses, but they already exist as such and do not satisfy the policy requirement for a mixed-use development. They are also dealt with as separate placemaking principles, i.e. separate requirements in bringing forward the development. If those separate principles, placemaking principles 9 and 10, dealt with the requirement for a mixed-use development, then the requirement would not be needed in placemaking principle 1. And again, it would be unnecessary or would not have been included. And finally, on this, although there is no such alternative use specified in the policy, that cannot negate the policy requirement. It provides flexibility to the developer. However, the proposals do not include any community, retail, employment, or any other use which might allow the development to be a mixed use. So although we do not, of course, challenge the sustainability of the proposals and the advantages of the site in that respect, as acknowledged by the core strategy inspector, that does not mean that underlying implications arising from a lack of true mixed use are not relevant and valid, as explained by Mr. Reynolds. The link to comply with PP7, which we've been discussing earlier in a different context, will inevitably and through no fault of the developer have limitations, as Mr. Reynolds described it. It will be unlit and also recognised in the officer's report to be suboptimal. Therefore, alternative uses on the residential development would assist and help improve the quality of the development. These concerns are exacerbated by the fact that the mixed-use development applied to the allocation of around 300 dwellings, but the appeal proposals would result, of course, in a much greater number, making the value of some alternative use or uses even more important. So I turn from that then to the final matter, and that's the planning balance. So as said in our opening, there is no doubt that there is an acute national housing crisis and an acute need for affordable housing within the authority's area. Equally, there is no doubt that proposals would deliver significant benefits, particularly in terms of market housing and affordable housing. Nothing I say seeks to go behind that. But Mr. Rouse is quite right to attribute, therefore, significant weight to each of these. He also cogently explained why it would not be appropriate, even accepting Mr. Stacey's evidence, for those to be attributed very significant weight, as the appellant has done. In a situation where the housing land supply and the housing delivery tests are met, that would be inappropriate. As an example, if you may recall, he said there would be nowhere to go in terms of a situation where an authority had, say, a 2-year housing land supply. And we would suggest, sir, that is a compelling argument. It is also consistent with the approach taken in national policy. As Mr. Frampton acknowledged, the appellant does not and cannot rely on the tilted balance on paragraph 11 of the framework. In terms of weighing the benefits and harms arising from the proposals, the authority's reliance on the conflict with the development plan is itself consistent with the approach within the framework. If so, you accept the authority's case that the harm to the national landscape provides a strong reason for refusing the proposed development, the tilted balance would not apply, and it wouldn't have been applicable even if the housing land supply and all the housing delivery test requirements were not met. That approach reflects, as Mr. Frampton did accept, the importance given to national landscapes in national policies. It trumps in that way the housing need. That approach is also reflected firmly in the amendment to the PPG in 2019, which not only makes clear that the scale and extent of development in national landscapes should be limited, but also makes clear that the frameworks of policies protecting national landscapes may mean that it is not possible to meet objectively assessed needs for the development in full through the plan-making process. That is all notwithstanding the undoubted importance of that need on which, as noted above, the appellant understandably places heavy reliance. However, that heavy reliance cannot, in the circumstances of this case, outweigh the great weight to be given to the harm to the national landscape. Nonetheless, that does not mean that meaningful development and contribution to housing and affordable housing would be prevented. The authority is, as emphasised above, not seeking to go behind the allocation of around 300 dwellings in accordance with policy B3A. That itself would be consistent with the requirements under B3A and deliver meaningful market and housing and related and affordable housing and related benefits. The authority is simply seeking compliance with the allocation, as is clear from reason for refusal 1, and that would be an effective use of land while safeguarding the national landscape, entirely consistent with Chapter 11 of the framework, making effective use of land. There is no suggestion that the appellant, either itself or through a development partner, would walk away from the site if the proposals are rejected. And indeed, that seems clear from Mr. Frampton's rebuttal proof, where he deals with the matter of permissive path, if you recall, sir. And although we consider that the impact on the national landscape to be fatal to the proposals, it should not be forgotten there is also other harm to be weighed in the balance. The first of these is the failure to provide the mixed-use developments as required, a requirement by PP1, the placemaking principle 1, as I've just addressed. And second, of course, is the issue of the impact on the heritage assets. The authority is, of course, not suggesting that the harm to the significance of the heritage assets outweighs the public benefits that would arise. Nonetheless, it does weigh in the planning balance against the proposals. The significance of these assets is clear from Miss Baldy's assessment of each in her proof, and her assessment of impact on these from the proposals is summarised in her table in the conclusions of her proof. The W8, the World Heritage Site, and the Wansdyke are heritage assets of the highest significance in accordance with the PPPF, paragraph 213B. The impact on the significance of the heritage site, both directly and on its setting, is assessed by Miss Baldy to be less than substantial at the mid-level of the spectrum of that in terms of the proposed built form. And she also put it at the lower end of respect to the access road, which would, of course, be required for an allocation compliant development in any event. And we recognise that. Quite how the appellant says there would be no harm to the significance of the World Heritage Site, as I understood their evidence, seems difficult to understand. Miss Baldy explained at the round table session why she concludes there would be less than substantial harm to the significance of the Wansdyke scheduled ancient monument by impact on its setting, but found it difficult to specify further the extent of that harm. And further, less than substantial harm would be caused directly to the Wansdyke by the crossing. However, again, it's acknowledged that the crossing is necessary and indeed will bring benefits. There is also the harm that would result to Sulis Manor as a non-heritage asset. So that all leads me to the conclusion. And I just say this, if I may, the appellant's reliance on the recommendation by the officers is entirely understandable. However, the members' concerns, in particular regarding the impact on the national landscape, have, we respectfully suggest, been vindicated by the evidence presented to this inquiry. And accordingly, the local planning authority respectfully requests in due course that the appeal be dismissed. So I'm grateful for your patience. Those are my submissions. Unless there's anything else you wish me to deal with at this stage.
Thank you, Mr. Morgan. I'm sure Mr. Tucker will pick up on anything in your closings that as he wishes. One thing I wanted to say was, I think in paragraph 65 you refer to Mr. Reynolds attributing significant weight rather than very significant weight. I think I stand to be corrected, but I think the wording used was substantial weight or very substantial weight. So are you happy for me to correct that?
I'm perfectly happy. I mean, I don't attribute difference myself, but yeah, I'm happy. You are right. That's what he said. Thank you.
That's okay. Just consistency of wording. I know one could
debate
it's important. The words themselves, but the wording consistency. Thank you. Otherwise, I don't have anything else to pick up on your closing. So thank you for delivering those.
Thank you very much.
So, Mr. Tucker, then obviously we'll hear the appellant's closing submissions next. Do we want to take another break before doing so?
So I would certainly welcome a 5-minute comfort break and just to stare at something other than the screen, if that would be possible. But I don't need longer than that. Okay. So I'm in your hands.
Okay. Well, shall we say, and then obviously in terms of length, how long do you think you need?
So you'll appreciate that I'm dealing with two overlapping but actually quite different cases. So my closing is actually 48 pages. However, there's about 10 of that I'm not reading. Right. So I would anticipate about an hour and a half, which is what I think I estimated last week, if that's acceptable.
That's fine. Well, on that basis, shall we go for a 10-minute break rather than 5-minute break, just a bit longer? And if obviously that if that can be emailed through now, then obviously we can have it ready for when we come back.
Thank you, sir, by all means.
Thank you. So unless there's anything else from anyone else, then we'll adjourn for 10 minutes and we'll come back at 2:20. Thank you.
Thank you, sir.
Hello everyone, it's 2:20 and the inquiry is resumed. I have a copy of the appellant's closing submission. I see that's been added to the inquiry website as ID 44, I think. So just so we know, but otherwise, I think unless there's anything else, we're probably ready to make a start, Mr. Tucker.
Just one point before I do, sir. Mr. Frampton has asked me to just ask through my learner friend, Mr. Morgan, if his planner would mind just getting in touch with Mr. Frampton to have a quick chat about the building heights condition. I'm sure that it will be a bind to drag him away from the next hour or so of his life of listening to me. But if that was possible, that would be splendid. Thank you, sir. So we can report back in a meaningful way, hopefully at the end of the afternoon.
Thank you. Yeah, Mr. Morgan, I'm sure that can be passed on. Yeah.
I thought they would be liaising anyway, but I'll prompt them. So
I think they couldn't tear themselves away from you, Mr. Morgan, I'm afraid.
That's the first.
Okay, thank you for that. So if there's nothing else, then Mr. Tucker, please make a start when you're ready.
By all means, sir. Introductory matters first. So, as you are aware, this appeal relates to a proposed residential-led development of a site in a sustainable location, which is allocated for residential development in an up-to-date plan. It lies in a district which relies upon this site in order to meet its adopted plan requirement. It has what is agreed to be an acute need for 40% affordable housing, and it is nowhere near its emerging plan being adopted, notwithstanding that its local housing need figure has now doubled as of last year. Had that not been enough, on the last day of evidence, the council produced a document entitled Resetting the Bath and North East Somerset Local Plan and District-Wide Spatial Strategy, which observed at paragraph 7.1 in respect of its reset of its emerging plan. And so I then set out the full quotation for the City of Bath, which talks about acute need, but I'm only going to read out the highlighted part, if I may, in which it says, we, the council, are also considering whether any sites already allocated for development in the adopted local plan could be intensified to provide additional development over and above what is already allocated. So in an inquiry where the only witness who addressed the important national policy imperative of making efficient use of land, that being Mr. Frampton, it is ironic that such a confirmatory statement of that policy imperative, the ongoing need and the lack of alternatives, comes from the council itself. The application has been with the council for 3 years and comes before you, sir, for determination in the context of the most acute housing crisis in living memory. This, sir, is not how the planning system should operate. So the rationale for our case is twofold. Firstly, the development plan process can rarely identify with precision the housing capacity for any development site. A fine-grained determination of capacity is usually the product of the development management system, by which time the constraints and opportunities of a site will be better known. And secondly, sir, yes, national policy requires land to be used efficiently, subject to other relevant considerations. So this proposal does not maximise the extent of built development, but it seeks to use land efficiently, consistent with other policy objectives. Most importantly, that of limiting impacts on the AONB in the context that this is an allocated site and that even the Cotswolds National Landscape Board consider that exceptional circumstances are made out for the principle of development. So at the inquiry, you've heard that the council invite dismissal only in respect of reason number 1 and a bit of the remaining reason for refusal number 3. They do not align themselves with the Rule 6 parties case that the appeal should be dismissed for any one of for a raft of issues, albeit that evidence was only led substantively on highways and master planning. And just pausing there, that's why, sir, our closing submission addresses that raft of issues, but I'm going to focus upon the ones where you've heard significant evidence. So both of the other two main parties have approached their evidence on the erroneous basis that the reference in policy B3 to an, quote, around 300 figure provides some sort of presumptive maxima of 300 units. The first sentence of the policy is agreed by all three planning witnesses to simply identify the likely plan period yield and could be plus or minus in any event. In fact, it is the last sentence of placemaking principle number 1 that tells one anything about the policy approach to that figure. It is not a cap. Or viewed in a more contextual matter, If a proposal is found to meet the relevant placemaking principles in the policy, then there is no cap on capacity found in policy B3A. And that's that fundamental point sits at the heart of this appeal. And whilst that misapprehension has plainly informed much of the opposition to this scheme, all of the professional witnesses at the inquiry confirmed before you, sir, that this is not a numbers game. What counts is the disposition and effect of development. Officers have always recognised this, both in the officer's report on this application, but also historically. The planning officer reporting to the 2019 Planning Committee on the application for full permission for Phase 1 under the heading of Principle of Development drew attention to this, sir, and then the quotation you've heard a number of times, so I won't read that out, but about the higher capacity of the site and the original 300 being conservative. So despite the suggestions made by Mr. Reynolds to the contrary, it is clear that those comments quoted in 2019 to the local examination, as reported and agreed by Mr. Reynolds in cross-examination, there is simply no evidence to doubt the truth of what officers said. There is no evidence before you, sir, to suggest the council didn't make representations to the examination in that manner, as confirmed by Mr. Reynolds. And Mr. Reynolds also agreed that it's an issue which is relevant for your determination and the council have had time to investigate the matter and put any contrary evidence before you if it wished to do so. The inspector's report on the placemaking plan likewise noted, paragraph 124, that the capacity of 300 dwellings set out for allocation of odd down in Bath is likely, having regard to pre-application discussions, to increase by 100 to 150 dwellings. Yes, of course, that will have been informed by what the developer said, but the language too is unequivocal. It's the inspector expressing an informed view. Mr. Reynolds agreed in cross-examination that policy B3A is a straightforward one, and if you, sir, conclude that a proposal meets all the relevant placemaking principles, the proposal accords with policy, notwithstanding the proposal will be in excess of 300 units within the allocation. He also conceded, sir, the passage didn't simply report the developer's aspiration and only the relevant placemaking principles need to be met. So I then quote what we already quoted in opening. So again, I'm going to skip through that about the nature of government policy and about the ambition to increase housing land supply. And we also, sir, quote again the stark imperative to local authorities from the Secretary of State. And sir, I then turn to mandatory housing targets, paragraph 19. The mandatory housing targets the local housing need under the revised standard methodology for Bath and North East Somerset is increased from 717 homes to 1,471 new homes. An average annual net addition of some 754 homes, new homes, is required now. This underscores, sir, the need to deliver the allocations within the adopted plan and to carefully bear in mind that any identified development land should be used efficiently, consistent with other planning and land use objectives. And so that's a reference to paragraph 130C of NPPF, which tells you if they're not using land efficiently, you should refuse permission. The suggestion that council can demonstrate a 5-year land supply does not mean that the housing crisis, doesn't apply in this part of England. Having a 5-year land supply does not mean that allocated sites don't need to come forward. Nor does it mean that where sites are released from the Greenbelt that they shouldn't still be used efficiently and properly. The 5-year land supply, sir, is not a maxima at which the supply tap can and should be turned off. It is rather the absolute minimum policy requirement of government. Mr. Reynolds accepted that since the local housing need has more than doubled since last December, that there are going to be difficult choices to be made. Even under the 50% lower local housing need back then, the local planning authority had given some consideration to releasing a large swathe of Greenbelt land west of Bath, albeit that Mr. Reynolds said that this wasn't likely to be released, and he also agreed that when looking at Greenbelt release, it would be incumbent upon the decision maker to consider the extent that needs can be met without going into the Greenbelt. He accepted that paragraph 130C of NPPF stands as a very strong policy imperative to make efficient use of land, and whilst not excluding other policies, it does not say that it doesn't apply to designated areas, or rather, taking out the double negative, it does apply to designated areas. The requirement is to balance competing objectives, including that making efficient use of land is an important consideration. And yet, despite that acceptance, that important consideration did not feature anywhere in the council's evidence. The only likely implication being that this important principle hasn't formed a substantive part of the council's judgment. And despite Mr. Reynolds suggesting in cross-examination that he had somehow taken it into account, but hadn't evidenced it. And coincidentally, the principle didn't form any part of the Rule 6 party's evidence either. Notwithstanding that Mr. Waters also accepted it was a material consideration before you. Mr. Stacey, whose evidence wasn't challenged by any of the parties, specifically stated that the level of provision offered by the scheme to meet core policy CP9 and site allocation policy of the development plan was 40%. He told us in his written evidence that the adopted core strategy sets out the minimum affordable requirement of 3,290 affordable dwellings in the 15-year period going up to 2029, equivalent to 183 dwellings per annum informed by the 2013 SHMA. Skipping a little bit further down, sir, we now know, sir, going to E, that the local housing needs assessment, the up-to-date one, sets out that there is an ongoing need for 831 dwellings per annum in Bath and North East Somerset, equivalent to a total of 16,620 new affordable homes in the 20-year period going forward from 2022. And that the council has under-delivered against its core strategy in terms of affordable housing for the last 4 consecutive years. So turning to H, against the more appropriate and most up-to-date assessment of affordable housing need in Bath and North East Somerset provided by the 2024 Local Housing Needs Assessment, affordable housing completions, net of right to buy, have averaged just 85 net affordable dwellings per annum since the start of the 2024 LHNA period of 2022-2023, against a need which is literally an order of magnitude greater of 831 net affordable dwellings per annum. That's produced so far, 2 years into it, a delivery shortfall of 1,407 affordable homes in the first 2 years of that period. And that shortfall will grow unless more affordable homes are delivered in this district. And finally, Mr. Frampton points out not simply that the emerging local plan is a long way off, but that only 3 sites have been proposed thus far, which actually meet the policy requirement of 40%, one of which is phase 1 and the other of which is this one. So it is in the context of clear housing need, and in particular an acute affordable need, and no plan to address it, that you, sir, are invited to determine this appeal. I turn, sir, to the reasons for refusal in turn, and so it's not my habit either to read out footnotes, but sir, I've added a couple of footnotes in response to what my learned friends have said. So, sir, I'm going to pick those points up because those are responsive points rather than points which essentially give you the references to the closing submission as written. So the first footnote that I draw attention to is footnote 24, which draws attention to the Fides case. So that case, now ID 39, deprecates using background documentation to interpret development plan policies unless the policy's interpretation is said to be obscure and ambiguous. That's paragraph 56 of Mr. Justice Lindblom's judgment, as he then was. That said, it is of course interesting that within Mr. Morgan's lengthy review in his closing of the history behind policy B3A, he actually omitted a crucial last chapter, namely that officers reporting to members twice, once in 2023 and once in 2024, and the latter being AC12 and AC13, officers consider that a scheme of 290 units in addition to the 171 consented units would accord with B3A. In other words, consistent with the view expressed at the time of the Phase 1 officers' report, which I've quoted above, the fact that around 300, sir, I missed the numbers 300 there. The fact that around 300 is a conservative assessment of the allocation's capacity is not a frolic of the appellant's own. It is with respect the consistent view of officers reporting to their members seemingly over years. The problem is perhaps the presumably psychological heuristic of grounding because the number 300 happens to appear twice in the policy itself. Reverting then, sir, to paragraph 27. So policy B3A is obviously the key policy. On our evidence, the scheme is policy compliant and is very likely that the exceptional circumstances, forgive me, sir. On the appellant's evidence, the scheme is policy compliant, and as such, if it was, it's very likely, sir, in Mr. Frampton's view, that the exceptional circumstances test of paragraph 190 is met. Notably, Mr. Reynolds agreed that the fact that the site is allocated and complies with the policy, if, sir, you find it to be compliant, that will be a powerful consideration when assessing the scheme against paragraph 190 of MPPF, to which I now turn. And so dealing with paragraph 190A, first of all, which is the need threshold. So we say that we have amply shown that the delivery of this allocation is still needed, not least by the proposed retention of the allocation unaltered within the recently adopted local plan partial update in January 2023. The council has agreed in the statement of common ground there is an ongoing and acute need for affordable housing within the district and in Bath in particular. And it was agreed both by the core strategy inspector and Mr. Reynolds that this is the right place for such development. So the council has not advanced the allocation of an alternative housing site to this one in the local plan update. No alternative site was identified in the council's statement of case. But in its evidence, Mr. Reynolds has tentatively pointed out that in the update, 3 additional small allocations had been identified within the urban area, in addition to retaining the allocations of the core strategy. Not only are they not alternatives, they're additions, but those supposed alternatives don't even meet 1 year's worth of the projected housing need within the council's emerging evidence base of affordable housing need. This site, together with phase 1, and possibly one other site in the district, are the 3 sites where it's understood from the planning officer that policy compliant affordable housing has been achieved. The loss or delay in the delivery of this level of affordable housing would be socially regrettable and significant economically. We also say, sir, that the appellant, mindful of the first of the 190 tests, has demonstrated compliance with the amended duty that arises from section 85 as amended of the Countryside Rights and Way Act for all the reasons set out in Mr. Cale's evidence, and particularly Mr. Frampton's supplementary proof. Mr. Stacey, as I've intimated, sir, has set out starkly the acute need for affordable housing in this district. And sir, Mr. Reynolds agreed that when looking at paragraph 190A, affordable need is part and parcel of the need that has to be borne in mind. I then deal with, sir, paragraph B of paragraph 190 of MPPF. Retention of the allocation with the recently adopted development plan demonstrates in the clearest possible way that there isn't an alternative way of meeting the need for housing other than this allocation. Had the position been otherwise, the local planning inspector would not have concluded that there were exceptional circumstances to endorse the allocation. As it is, with respect, there is no meaningful evidence of any serious alternative. Indeed, in this case, the paradox is that all parties appear to accept the release of this land, and so the focus has been not upon whether there is in fact an alternative to the release of this parcel of land for development, but the effect of the amount proposed compared to what council has wrongly considered to be a de facto cap on numbers on phases beyond phase 1. And then C, any detrimental effect on the environment, the landscape and recreational opportunities, and the extent to which that could be moderated. This is the real battleground, of course. Recreational opportunities have been significantly enhanced through the creation of a public rights of way network, in contrast to the subsisting arrangements of permissive paths, which will be withdrawn in an appeal dismiss world. The evidence of Mr. Cale sets out the appellant's case in respect of landscape. At the outset of cross-examination, he patiently explained to my learned friend that this was not a numbers-led scheme, but rather a scheme where the likely yield from the site derived from assessment of the likely landscape capacity. That is to say, unlike the near obsessive approach to numbers undertaken by others, he has considered the likely effects of the proposal across the plateau, with particular reference to the disposition of where housing was and was not appropriate, and what height might be appropriate, mindful of the need to minimise, though not entirely avoid, the effects of the development in this sensitive location. His evidence explains the embedded design mitigation with respect to landscape and visual issues, and includes elements of mitigation which would limit adverse effects upon the AONB, National Landscape Now, along with respect to its special qualities. And so I then summarise what those mitigation effects are. Firstly, the proposed development is actually well contained within land allocated for the residential-led development, but deliberately draws back from the southern and now also the northern tree belts, both of which will be strengthened. And as for the eastern relationship to South Stoke, that will be protected by extensive tree planting in the intervening field. So I should just perhaps add in relation to South Stoke, on the very first page of the closing submission, we actually highlight that South Stoke is identified as a sustainable settlement that could accommodate some additional development in the reset document. Things are that desperate in this district. Turning back to Mr. Cale's mitigation, sir, B, the design process and development proposals have been informed and shaped in response to both the planning policy context and also a range of technical appraisals. There have been revisions to reduce and limit the extent and indeed the height of built development with various design iterations. So reducing the extent of built development within the planning application through the relocation of allotments from Derrymans to the northwest corner of phase 3, and to reduce and limit the maximum height of the proposed development within the building height parameter plan currently before you, which limits building heights to 2-storey in some areas, some elements of 2.5, and also limits the proportion of 3-storey built form. And sir, the revision to the location of tree planting to 30 acres field, which is of course the east of the site. So the other important element of mitigation is the green infrastructure plan, which sets out key elements of embedded design mitigation, identifies retained vegetation around the site, located within proposed areas of public open space with development offset to respect root protection areas and bat habitats. There are substantial areas of public open space with opportunities for tree planting. There's an area of replacement tree planting located to the east and the area of allotments to the northwest. There's also, sir, the proposed landscape and management plan that especially relates to the existing southern tree belt, which needs management with ash dieback, with proposed planting and management to reinforce and enhance this feature so as to create a long-lasting, well-structured broadleaf woodland. There's also, sir, the lighting parameter plan, despite some scepticism expressed without evidence by some of the people you've heard, sir, which shows how lighting impacts have been minimised. That includes a recognition of the sensitivity of the location within the national landscape, and particularly with regard to ecology issues as well. Indeed, since the light spill to the northern boundary of the southern tree belt will be a practically dark night at that point, that logically means that views from much further to the south will be even darker. And with respect to Miss Prescott, sir, it flies in the face of the evidence to suggest that this will be a housing development lit up when viewed from the south. Mr. Cale sets out specific responses to the special qualities of the national landscape, evidencing that these have been carefully taken into account by the technical disciplines in the design process for the proposals. So they've been informed by such inputs to variously avoid or mitigate adverse impacts, and in some instances show enhancements. Overall, the proposed development has been demonstrated to limit the adverse effects on the AONB, and in addition, enhancements are provided which assist with conserving and enhancing its natural beauty, which furthers the purpose of the designated landscape in accordance with the requisite duty. But so in a profound evidential cul-de-sac in cross-examination, the council sought to emphasise the difference between limiting and minimising effects. In this regard, Mr. Cale's answers were clear. He's used the terms interchangeably, and there's nothing of substance in this point. It's a matter of form, not substance. Mr. Cale also clarified during re-examination that it's clear that in terms of the South Stoke Conservation Area appraisal, that identifies important views, ironically none of which point towards the appeal site. He also explained the baseline, and the council's referenced the combined effects of phases 1, 3 and 4 in view of phase 1 now having been substantially completed. That means it forms part of the baseline and isn't part of a cumulative assessment. And insofar as phase 1 will be visible in views from the south, that's now part of the context of the appeal proposals, and it isn't an additional harm in the way assessed by Ms. Prescott. Overall, it's fair to say the appellant's case on landscape withstood forthright challenge, noting that Mr. Cale's rebuttal evidence substantially addresses points made in the council's written evidence, in particular the council's rather odd reliance upon only a partial understanding of what had been put before the core strategy inspector. In contrast, the council's landscape case fared less well. Insofar as the oral evidence at the inquiry was concerned, you, sir, will recall that Miss Priscott's evidence was to the effect that around 300 dwellings in Policy 3A was indeed, in her view, when I asked her, a cap, contrary to what Mr. Reynolds told me. Furthermore, you will recall Miss Priscott went as far as to offer an alternative scheme to the inquiry, which she's rather curiously assessed as 130 to 150 as a parallel assessment before criticising my clients for not doing the same exercise, despite the fact that nobody had ever asked them to do so. And interestingly, Mr. Reynolds, in his evidence, made it clear that the case isn't about numbers, but about effects on the placemaking principles, a position from which the council's evidence eventually concurred. Miss Priscott's points that the appellant hadn't engaged in alternative comparison exercise, certainly in her evidence in chief, seem to be based upon the EIA scoping opinion. The point's odd, as well as wrong in law. There's a legal requirement for the purposes of EIA to look at alternative schemes which have been assessed by the appellant. There isn't a legal requirement for the EIA to cast around to think of alternatives. Had the point been a serious one, then the council would have issued a Regulation 25 direction for more information. When this was pointed out, my learned friend properly accepted, and indeed has repeated in closing, that there has not been and is not a point taken by the council in respect of EIA scoping, which Miss Priscott also conceded in cross-examination. Indeed, after Mr. Cale had been asked to walk along this particular forensic blind alley in cross-examination, he clarified in re-examination that there have indeed been various iterations of the scheme, in other words, parameters reflecting changes. He's also confirmed that despite the application having been with the council since May 2022, there's been no request to supplement the design and access statement by testing further quanta. To raise the point that there's an evidential deficiency, though not an EIA deficiency at this stage, is downright odd and with respect misguided. In her evidence, Ms. Priscott has emphasised the importance of permissive paths and associated views. She's also conceded that given that permissive paths agreement expired in 2022, looking at the views from those paths is looking at views from paths that are there at the discretion of the appellant and could be removed at any stage. And she accepted there's a clear difference with respect to the weight to be given to those receptors. Think about it, sir, with respect, because the corollary of that point is that all the amenity value that she ascribes to those views in her written evidence positively underscore the benefits of those routes being secured by this appeal. Yes, they would change, subject to the mitigation of the appeal scheme, but in an appeal allowed world, those valuable routes will be retained as publicly available routes. In respect of Ms. Priscott's point in respect of dark sky components of the AOMV, Ms. Priscott was not talking about the impact of the built development itself, but rather seemingly other source of light, because she doesn't question the assessment of must be, the word she referenced car headlights, etc. In respect of figure 98, Ms. Priscott's suggestion in respect of likely impacts, she accepted that there is no part of phase 3 or 4 where 3-storey buildings are immediately adjacent to the southern tree belt. Instead, saying that these were quite close, that despite her suggestion that one needs to draw a comparison between a tree at 12 metres and a house at 14 metres, the 3-storey element of the parameters plan, sir, is set well back from where the 12-metre trees are. And the council does not seek to suggest, or hasn't sought to suggest, there's anything wrong with the building height parameters plan, nor has suggested there's anything wrong with 3-storey buildings in that part of the site. So it remains baffling how moving the 2 to 2.5-storey components of the scheme back by a further 36 metres would meaningfully diminish the appearance of the height of the built form visible above the trees viewed from over a kilometre away, when that height would actually arise from a different part of the site. Not only, sir, is the dotted line not a predictive line, it is a maximum height subject to reserved matters, but it wouldn't be diminished by increasing the offset from the southern tree belt. That said, if this was an issue, sir, as we've candidly said through the evidence of Mr. Frampton, you, sir, could, of course, consider conditioning building height. Mindful, of course, that this suggestion arose from our side and not the council's side, nor indeed, sir, has it arisen from the Southwest Design Review Panel. Miss Priscott's evidence was, with respect, a very generalised criticism to the effect that having less houses, then the effects will be minimised. The inescapable conclusion must be that her point is that the issue is indeed with numbers. And yet Mr. Reynolds' evidence is the contrary. It's not about the numbers, it's about effects, a point which you'll recall Miss Priscott eventually accepted in cross-examination. So which one of those reflects the council's position remains unclear, but Mr. Reynolds' analysis makes more sense. And rightly, Ms. Prescott rightly accepted that policy B3A did not require the development to be invisible when viewed from the south, but rather properly mitigated. But she was on occasion willing to flirt with exaggeration rather than assessment, and thus the red line on the photo montages was described by her as being the likely effect of development in her examination in chief. But she conceded it to be the maximum parameters in cross-examination. And in terms of the width of her view across the plateau, Ms. Prescott accepted in cross-examination that despite her suggestion in examination in chief that phases 3 to 4 would double the width across the skyline compared to phase 1, they were in fact 1.5 times more and not quote slightly twice. Even Ms. Prescott's case in respect of the around 300 dwellings from the first sentence of B3A of the first placemaking principle differs from that of her client. Her evidence is in essence to the effect that only much less than 300 units is acceptable, but that's not the council's case. When asked about the first sentence of B3A, which clearly refers to delivery within the planned period and doesn't set out the maximum yield, Ms. Prescott maintained her position, which is contrary to that advanced now by my learned friend in closing. Ms. Prescott agreed that the LVIA is fit for purpose. She doesn't criticise the scheme in respect of the fifth placemaking principle on landscaping principles in respect to the first or second sub-bullet points in respect of ensuring screening of the site in views from the south. She doesn't suggest that the requirement is to make the proposal invisible. She agreed that if the southern tree belt were properly enhanced by additional planting, that there would still be glimpsed views of the housing, but that wouldn't necessarily amount to a failure to adhere to that bullet point, and the third bullet point could still in principle be met. She agreed that the reference on the concept plan to avoid building in a particular area only relates to the northern field and not any other part of the site. And she also agreed that USER should bear in mind the acceptability of where to build has been left to the development management process, despite being taken into forensic archaeology. USER will of course recall as well that she failed to bring some key points to the attention of the inquiry. In respect to the planning inspector's examination of the council's core strategy, Ms. Prescott failed to flag in her evidence the inspector's reference to the land within the odd down plateau proposed for the allocation as being much less dramatic, said the core strategy inspector, and distinctive landscape than that to the south. She agreed it was an omission. She also agreed that was an important piece of information when, sir, you are considering the question of harm. In respect of her proof, Ms. Prescott's clearly assumed red lines in the landscape and heritage assessment, which was before the core strategy inspector, had somehow been scrutinised and endorsed by that examination in the allocation when commenting upon the development being too close to the edge of the plateau and referring to her suggestion of the need to reduce the quantum of development. In cross-examination, when she was taken through the complete evidence before the core strategy inspector, that she does not now assume the red line that she relied upon to justify her 50 metres standoff to now be a hard line, but rather she now expressly conceded that that the core strategy inspector only had in front of him little more than what was described as a best guess, which left the southern extent of southern development on the phase 3 and 4 to be determined by future studies and by the development management process. Another forensic cul-de-sac. Mr. Cale put the point beyond argument in his rebuttal by producing the update report, which showed the dotted line as the likely extent of development, which was understood to have been produced later than the plans produced by Ms. Prescott. And the update report at paragraph 2.8 explains that the dotted line on Plan 6 should not determine the extent of where built development should take place, which should be established only after additional technical work's been undertaken, with the dotted line being no more than an indicative best guess, a point now agreed but never referred to in her evidence by Ms. Prescott. Ms. Prescott confirmed that she does not invite revision of the parameters plan, but maintains her insistence that there should be a 50-metre buffer, albeit at no point did the council seek to raise the issue or clarify where the 50-metre buffer was to be measured from before her evidence. After the application had been with the council for more than 3 years, the clarity was finally gained in her oral evidence on day 3 of the inquiry. Turns out that it's 50 metres from the northern boundary of the southern tree belt that is being proposed by her. In other words, the difference is 36 metres more than that which is being proposed by Mr. Cale. She conceded that there isn't an evidential basis for an argument for a need for 100 metres worth of depth, And Mr. Cale, in his evidence, confirmed that during the course of the application, there'd been nothing from the council to the effect the setback needs to be increased or that a total set of 100 metres was needed. Neither had there been any feedback to the effect that an additional 30 to 40 metres of planting was needed. That's in her written evidence, in addition to the southern tree belt, or an additional 50 metres, her oral evidence, in addition to the southern tree belt. Despite Ms. Priscott's reference to 300 dwellings throughout her evidence, she confirmed in her oral evidence that she had been aware at the time of writing her proof of the 450 figure referenced in the officer's report as the yield of the site in the LPPU. It was put to her by me that she failed to report in her proof that the council's formal position at the examination before the inspector was the capacity of the site was likely to be above 300 units. She confirmed it was something that we as a team had discussed. Ms. Priscott was asked multiple times to ask whether it's relevant for you in considering the site in landscape terms that the council had expressed the view to the LPPU inspector considering that this particular phase one, that the 300 unit was a cautious approach and the scheme with a higher capacity could potentially come forward and conform with the placemaking principles. Ms. Priscott, to her discredit, you'll recall, sir, elected not to answer the question, and Mr. Reynolds unsuccessfully sought to sidestep the point. It is with respect an oddly partial approach to presenting evidence, which is perhaps the legacy of an authority who only ever allocated this site because it was essentially told that its core strategy would be unsound if it didn't do so. Bringing all that together, sir, we would invite you to prefer the evidence of Mr. Cale. So can I then turn to paragraph footnote 74, if I may, sir, which is a response to Mr. Morgan's closing. I think this is only the second of two responses I need to make to Mr. Morgan's closing, and I'll read it. This is a response to paragraph 45, sir. So much emphasis was placed by my learned friend in his closing upon Mr. Cale's reliance upon the Bath building height strategy. It remains baffling that the council still places so much emphasis upon this document. Not referenced by Ms. Priscott nor Mr. Reynolds in their proofs, yet Mr. Cale fairly drew attention to it, but Mr. Frampton, as a planner should, addressed its status and its scope. Its status is that it isn't an SPD. It was meant to have been, but it never made it, and therefore, as policy, it can only have limited weight. Its scope is that it doesn't include the appeal site at all. That's with the exception of Sulis Manor, of course. And when views to the hills are referenced, the concern relates to views to the hills from the Georgian city. The document is interesting by analogy, but it barely advances anyone's case, unless, of course, one was seeking to bolster a weak case in the skillful way that Mr. Morgan has sought to do so. So can I then revert to compliance with the placemaking principles and paragraph 75, the first placemaking principle? So we say the proposal is consistent with an allocation which seeks a residential-led mixed-use development under policy B3A. The appellant has emphasised the reference in the policy to the allocation and not to individual planning applications. The policy does not require each and every planning application for each and every part of the allocation to contain a mixture of uses. The appellant has already brought forward employment use for well over a decade within the allocation. To consider this scheme in a vacuum without the existing uses would be both artificial and, with respect, pointless. The reference is to the allocation as a whole. That said, the proposal includes new homes, public open space, double what's needed, and allotments, and comprises an essential part of a residential mixed-use allocation. No part of the policy, nor frankly common sense, requires each and every application within it to comprise a mixed-use proposal. Mr. Frampton, of course, has also addressed the average density of the site, and his evidence in this respect stands unchallenged. Placemaking principle 2. It's agreed within the statement of common ground that the comprehensive master plan submitted with the application satisfies placemaking principle 2. Mr. Reynolds agreed that the second placemaking principle is met. And despite that, well over an hour and a half of Mr. Frampton's life, time he'll never get back, was spent with the evolution and content of the master plan being explored by Mr. Neal. In the end, it still remained unclear where the point ultimately went and why the Rule 6 parties so what filter had been turned off at that part of the inquiry. So can I also then pick up the first of the points to respond to Mr. Neal at footnote 77? In his closing, Mr. Neal, for example, at paragraph 26, asserts that there is a requirement for there to be some sort of prior approval of the master plan before the grant of permission, perhaps even an SPD. With respect, that doesn't follow from either the words of the policy nor from the evidence of his own witness. Can I then turn back in the text, sir, to placemaking principle 3, paragraph 81. So this placemaking principle requires the provision of green infrastructure, well-integrated SUDs and habitats, etc. And other than the issue raised in the third reason for refusal related to the shared footpath cycle crossing of the Wansdyke, no objection was raised by the council as a consequence of the amount of housing proposed. So you've heard that evidence with respect to planting, and it's submitted very firmly. This principle too is met. Placemaking principle number 4. It is agreed between the council and the appellant that other than the objection raised in the third reason for refusal relating to the shared use of the crossing of the Wansdyke, the development will include a public right of way providing enhanced public access within the site and connecting well to the surrounding footpath network in placemaking principle number 4. And so I should add that's enhanced not just for future residents of the appeal scheme, but for everyone else as well, including residents of phase 1 and the public. So I then set out the approach with respect to what had happened in respect of phase 1, and also flag up the granting condition now proposed in relation to the Wansdyke, which we discussed this morning. So the fourth placemaking principle also met. Placemaking principle number 5, that requires a landscape and ecological mitigation strategy to ensure satisfactory mitigation and protection. The council doesn't suggest that any of the ecological requirements aren't met. We, sir, have demonstrated we say this allocation couldn't be delivered without the loss of some existing trees, especially in order to provide a road connection through Sulis Manor. But happily, with the demise of the second reason for refusal, the extent of replacement tree planting is agreed. And the council accepts in the statement of common ground the form, scale and access of the access road and impact for tree loss within the grounds of Sulis Manor will be the same for that scale of development proposed in this application. Thus, as between the council and the appellant, the route across Sulis Manor is uncontroversial, but importantly, those words mean that the effects upon Sulis Manor would be absolutely identical whether phases 3 and 4 are developed for 290 or 150 units. So the GI parameters plan shows the southern tree belt being protected and strengthened. The obligation in the 106 gives effect to its future maintenance and access. And then, sir, paragraph 90, whilst third parties have maintained that further testing of the Sulis Manor Road is warranted, that appears to have been founded upon the assumption that the design access statement on phase 1 somehow needs to be revisited and reassessed. It doesn't. Phase 1 established the deliverability of the route through Sulis Manor by the 106 obligation, but crucially, the spur into Sulis Manor land from phase 1 stops at a different place to the option 1 in the design access statement. As a result, the appellant's witness team explained, that's a week last Friday, sir, that in order to go onto Burnt House Lane, it would require a different approach to meet requisite highway standards, which Mr. Pinto has then evidenced and which confirmed Mr. Rose's assessment that more valuable trees will be lost that way. The third party response which you got yesterday, sir, is with respect misguided. So the development of greenfield land can't be undertaken without having some adverse impact and effects upon the site itself in terms of character and appearance. The impact of built development cannot be avoided, and that's true of the allocation overall and true of the route through Sulis Manor. You, sir, heard the evidence to the effect that in examining and endorsing the allocation, the core strategy inspector considered that localised and an overall moderate level of harm to the AONB would arise from the allocation, a position that Mr. Cale has used to sense check for the appeal proposals, and he considers, sir, compellingly that the appeal proposals subject to mitigation would indeed have no greater harm than that which was assessed by the inspector at the core strategy examination. And despite Miss Prescott's best efforts to do so, it's just occurred to me, sir, of course, that Miss Prescott shares the same initials as Mr. Pinto, so apologies for that when I turn to the highways and I use his initials. I'm sure it should be obvious which ones I'm using at which time, but apologies for doing that, sir. Amazing, as Mr. Morgan says, how many times you read these things and don't spot an obvious point. So, paragraph 93, despite Ms. Prescott's best efforts to do so, the council has failed to substantiate any suggestion that there will be some additional harm to the AOMB over and above that assessed by the core strategy inspector through the detail for this development, which would not otherwise have arisen from the development of the allocation in any event. The appellant has stressed throughout the inquiry that the fifth placemaking principle landscape requirement doesn't require the mitigation strategy to ensure all harm is avoided. It couldn't. A position which is understood to be common ground between all the professional witnesses who appeared before you, sir. The key point, sir, is the impact of development we say has been minimised, presupposing the allocation. The fifth placemaking principle require provision of enhancements to important landscape features. And sir, as Mr. Cale explained, we have sought to address that, and those are set out at paragraph 96. So we've also satisfied the requirement with regard to the landscape strategy plan, which we set out at paragraph 97. And so we have demonstrated that the amount of housing proposed would have no adverse consequences for a satisfactory landscape and ecological mitigation strategy required by the fifth placemaking principle. And then, insofar as there's a difference of opinion in respect to the tree belt and the sufficiency and the issue of standoff, the issue, of course, is one before you, sir, as whether you prefer the evidence of Mr. Cale or Ms. Prescott. But for the reasons that I've already extensively set out above, we would invite you to adopt the evidence of Mr. Cale and find this placemaking principle too is met. Placemaking principle number 6. So the council has withdrawn the second reason for refusal on the basis that the merits of the proposal now outweigh the alleged less than substantial harm to the World Heritage Site. Interestingly, though, that's not because it considers that it got it wrong in the first place, but rather because it considers that there is now an increased need for housing as a result of the new local housing needs published in December, a point, sir, which spectacularly underscores the need case which we've discussed above. No issue has been taken with the parameters plan in relation to green infrastructure and lighting. And the sixth placemaking principle seeks to conserve the significance of heritage assets. The council doesn't advance an objection that this scheme conflicts with the sixth placemaking principle to amount to conflict with the development plan or MPPF. And insofar as the Rule 6 party's objection is concerned, it's addressed separately below, but suffice to say that Mr. Waters has got the public benefit test wrong, and so I particularly refer to his cross-examination. So the seventh placemaking principle, sir, we say is eminently granted based upon passed based upon Mr. Pinto's evidence, and so I don't read out our position with respect to the 8th, 9th, 10th, or 11th placemaking principles. So I turn then to the second reason for refusal and the case advanced by the Rule 6 party in this regard. So you'll recall the Rule 6 party doesn't rely upon its own heritage evidence. So we rely upon our own heritage evidence that you have heard, sir, which we say paragraph 133 demonstrates there will be no harm to the significance of either of the World Heritage Sites, but that there would be a low level of less than substantial harm to the significance of the scheduled monument and a low level of harm to the low local significance of the non-designated asset of Sulis Manor. And I set out the reason as to why we say that the public benefits very, very clearly outweigh that low level of harm. I also deal with archaeology at 1.115, and so I say at 1.16 that there is a clear alignment between the council and the appellant insofar as heritage matters are concerned, and a lack of clear substance or indeed explanation to the concerns raised by the Rule 6 party and Mr. Waters' purported explanation. Third reason for refusal, sir. Obviously, Historic England will reach a balanced judgment as to whether there's a benefit to the one Dyke that itself outweighs the harm, given the great weight to the one Dyke as a designated asset. On the evidence before you, sir, there is the clearest possible indication that there is a likelihood that scheduled monument consent will be granted, and that the outstanding issues seem to relate solely to the construction, detailing and width of the crossing, not its principle. And so therefore, sir, assessing it on the balanced probabilities that that will be granted, the appeal should be determined on the assumption that the link will be provided should permission be granted. And so indeed you've heard that the application should be determined pretty quickly. So you've also heard our view that it's likely to be granted. That said, sir, paragraph 122, in the event that were the position to be otherwise, our position remains there would still be a satisfactory alternative for journeys to by cycle and on foot to local facilities, and the proposals would establish a sustainable pattern of development in the event that the crossing to the one Dyke isn't achievable. That issue should never have been part of a reason for refusal, notwithstanding, sir, there would be a requirement for a further step in the planning process, again, as you heard this morning. And so as the remaining part of the reason for refusal, the one that's retained by the council, the lack of mixed-use development of the site, so that is profoundly misconceived and fails to read the policy B3A correctly. In their opening submissions, the Rule 6 party argued that the appellant's reliance upon ancillary provisions is not a meaningful attempt to deliver mixed uses, a line of argument that completely ignores the fact that national policy promotes a sustainable pattern of development, and neither the NPPF nor Policy 3A requires each and every planning application to comprise mixed-use development, but requires, for B3A, the allocation to be residential mixed-use development, a requirement we comply with. The briefest perusal of a map reveals the appeal site's proximity to employment, education, retail, sports, leisure, as well as being close to major transport routes with buses. The allocation includes Odd Down Football Club and Manor Farm employment at site within the allocation, and the latter comprises a range of former farm buildings located at the southern side of the allocation, which have been converted to provide high quality employment space. Over 100 people are employed in those buildings. And yet, whilst agreeing that Sulis Manor and the football club are not in residential use, Mr Reynolds refused to accept that if the proposal was to come forward, that the allocation would then properly be described in terms of its consequence as a residential mixed-use development. Indeed, the policy actually expressly envisages the retention of both in the delivery of the allocation as an option. Any suggestion to the effect that the requirement only applies to new development is misplaced, because that belies the words which are actually in the policy. It's clear that the placemaking principles take account of existing uses, for example, the 10th, as agreed by Mr Reynolds. Furthermore, Mr Reynolds agreed that if the appellant was correct, i.e. if one could have regard to existing uses, then the proper description would be indeed mixed-use development. So the absurdity of the argument now advanced by the council is tested thus. Had my client waited and brought forward the employment as part of this development, noting that it's already spent a decade or more delivering it, it appears to be agreed that there would be compliance with this requirement, but because it's brought forward this application and the employment at a different time, the requirement is said not to be met. That makes no sense. The allocation following the delivery of the appeal proposals either is or isn't residential mixed use, and moreover, it either is or isn't part of a sustainable pattern of land uses. And with respect, the answer is obvious. This proposal isn't confined to residential development. So for the reason that Mr Frampton explained, I don't read out 133. And so in terms of the locational circumstances of the site, so I do re-emphasise that there is an extensive network of permissive paths which are to be made available, which wouldn't be if the appeal is dismissed, that will be formalised through the grant of permission. Securing those well-used permissive paths as of right as part of the public right-of-way network is obviously a significant benefit. So we've also demonstrated other elements which have been minimised by others, provision for public open space, allotments, the provision of the public right-of-way network, etc. So the criticism that the development would be a homogeneous residential development, reiterated by Mr Neal, is entirely misplaced. Mr Reynolds seems to have raised concerns in relation to the proposed link to the north. On the evidence, he appeared to doubt whether the road would be suitable for pushchairs and wheelchair users, and also referenced it to being unlit. When challenged, Mr Reynolds suggests his comments didn't relate to any of the matters within Mr Pinto's expertise and were limited exclusively to the issue of mixed use. It will be recalled, of course, that Mr Pinto did deal extensively with the accessibility of the appeal site. Mr Reynolds confirmed there is no issue with no car accessibilities. Mr Reynolds also confirmed the council isn't seeking any conditions requiring the surfacing of the one-site link being made so it's a better fit for wheelchair or pushchair users. He's conceded that issues of lack of accessibility or lack of bus penetration are just not raised by the council as live issues until flirting with them during his examination in chief. Which then brings me to the fourth reason for refusal, not maintained by the council, but maintained by the third parties. And so you have our position with respect to the tree lost through Sulis Manor. So unless you wish me to do so, I wasn't proposing to read those paragraphs, if that's acceptable. Thank you, sir. Turning then to the exciting issue of traffic. So this closing submission should have ended at this point with an invitation to allow the appeal. There is no other technical objection from any other statutory consultee to the delivery of these proposals, no outstanding Regulation 25 direction, no unmet request for further information, and yet despite 2.5 years of engagement with the local highway authority, resulting in their not objecting to the proposal on highways grounds, the parish councils, based on 1 day of active drone footage, invite you, sir, to reach the conclusion that the appellant, multiple officers of the local highway authority, and even councillors have got it wrong. Not just wrong, preposterously wrong, such that no reliance at all can be placed upon the transportation assessment provided by the appellant. In fact, so wrong that my learned friend Mr. Neil even turned off his hyperbole checker on his closing submission. Forensically, with respect, in the context of that, the Rule 6 party has a punishingly high bar to surmount to establish its case, but unhappily for it, it has come nowhere near surmounting such a bar. Standing back from the detailed submissions which I make in a few moments, there are some very, very big points here. Firstly, Mr. Russell hasn't produced any more work than Mr. Bales has done in his drone analysis report, and indeed in some respects he's produced less. Secondly, Mr. Russell, unlike Mr. Bales, does not allege a severe impact on the road network. Uniquely amongst all of the highway consultants, he doesn't consider that there's enough evidence to even form a view on the subject. Thirdly, Mr. Bales' work was considered by the local highway authority, who had by then considered that they had no objections to the scheme. They considered his work, did so carefully, assessed queuing, and maintained their position of no objection. Mr. Russell's evidence, next, was sent to the local highway authority, who maintained, even after reading what Mr. Russell said before you, sir, have confirmed they still maintain their position of no objection. If you just pause there for a moment, sir, it shows something of the confidence of Mr. Pinto in whether he really thought this was an on-balance issue or whether this was a slam dunk issue, that he drew it to the attention of the local highway authority and asked them the question. If you want a sense check, sir, that's it. Fifth point, sir, reverting to text. Mr. Russell seems to have based his assessment in his evidence on the assumption that the original TA had never been validated. That is just wrong. All of the model's input were based upon 2 lots of CCTV survey evidence, which were 2 years apart, of 7 different junctions, which were sent to the local highway authorities consultants and checked by them. Mr. Russell only has cited this data just before the inquiry, in other words, cited the CCTV, but then didn't push the point and has never checked it. Yet you are invited, sir, to the conclusion of presumed incompetence on the part of both the appellant and the council's appointed consultants who have actually looked at this information. Mr. Russell's point is not one of safety, he told us clearly, but that of congestion. And he accepted in terms that it is not part of national planning policy to make the life of the morning commuter more convenient. And finally, in terms of big points, in reality, what the drone footage actually shows you is that there is congestion in the AM peak at one roundabout entering the city and congestion in the PM peak when leaving the city at one roundabout. And whilst from time to time traffic will come to a standstill, for most of the time the roundabouts operate exactly as they should do. With respect, for all the time that was taken up at this inquiry, this too, sir, is a very large so what issue, and the appeal should not be dismissed on this basis. So turning then to the detail of the point, we say we've conclusively demonstrated in reliance upon Mr. Pinto's evidence that the scheme's active travel strategy ensures safe and suitable connections to the sustainable travel network aligning with national policy. It offers an off-site active travel scheme and prioritises non-motorised transport modes, promoting environmentally friendly and health-conscious travel behaviours. The allocation was rightly described as being highly sustainable, next to the most sustainable settlement in the district where it's allocated. There is no reason to take a different view now. And I pause there, sir, without asking for a response or reaction, but there can have been very few cases in your experience where the site is literally sitting next to the park and ride site coming out of a city such as Bath. It has even been shown that the pedestrian and cycle access strategy are acceptable, even if a permissive connection for cyclists over the Wansdyke isn't in place on day one, because of the multi-access strategy. The Wansdyke scheme is undoubtedly beneficial, as Mr. Pinto demonstrates, but isn't critical. The proposal is an enhancing element, especially for phase 1, and not an enabling one, we say. That's the approach of the TA. Mr. Pinto has also confirmed, in respect to the mixed-use argument that's been run by the council and the Rule 6 party, that the relevant facilities that you might want to access can all be accessed by non-car modes. And his evidence, sir, has also highlighted that there hasn't been a single instance of any request made in terms of funding or additional sustainable transport measures that has not been met, which includes, sir, over £630,000 towards this authority's ambitious sustainable travel initiatives heading towards 2030. But as to vehicular traffic, the summary position is the appellant has indeed demonstrated that the proposal aligns with NPPF, in particular paragraphs 109 to 116, and will not lead to severe cumulative effects, a position with which the council concurs. Mr. Pinto's evidence is clear that there may well be more congestion. However, appropriate mitigation has been put in place to manage the operation, including viable opportunities for sustainable travel modes. It's been confirmed there's been no outstanding request for further mitigation or works that hasn't been provided. Despite this, there's been a number of criticisms levelled at Mr. Pinto. The first of which is he hasn't constructed a dynamic micro-simulation model such as VISIM. Whilst phase 1 was assessed against such a dynamic model, and the Highway Authority asked for justification as to why phases 3 and 4 weren't, a clear explanation was provided, and the authority has agreed to the approach taken. Mr. Russell sought to argue, based upon Transport for London guidance, that a micro-simulation model ought to have been used, but with respect, we are in Bath and not London. The latter, London, being replete with complex junction interactions, where a micro-simulation model would of course be appropriate. In contrast, the study area here has 7 junctions which are spread sufficiently far apart to have minimal interaction, with the 2 principal roundabouts being essentially freestanding. There is simply no warrant for the additional expense and delay of building such a model in this case. Mr. Pinto's evidence has addressed the reasoning behind not using such a model and confirmed it would be rather odd, very abnormal, is what he said, to provide a micro-simulation model in circumstances where the council hasn't asked for one. But more importantly, Mr. Russell accepted that if the model he has used has been validated to meet Mr. Russell's concerns, then he would not have been arguing that the appeal should be dismissed on the basis that a micro-simulation model has not been produced. So the point, again, with respect, goes nowhere. On the issue of calibration and validation, the decision maker does not have to have before them the totality of the information that over months has been scrutinised by the local highway authority to allow them to reach the conclusion that a model is reliable. Mr. Russell may not have seen it, and his clients never asked for it, but Mr. Pinto has confirmed that not only did the appellant's team review the CCTV and calibrated the model, the local highway authority's consultants team also reviewed it, as a result of which they haven't raised any concerns about the CCTV being out of kilter with the models or requested any further work to be done on the models to bring them into alignment with the circumstances observed on the CCTV. Neither did the local highway authority request any review following the Alan Bales report. Furthermore, at no point was there any request made by the local highway authority for anybody else to create a systematic public-facing document that would reflect the observations of those reviewing the CCTV. Neither has one been produced by ACOM, the highway authority's consultant. And whilst Mr. Russell might somehow mark down both my client's consultant and the council's on his standards, here's Mr. Russell's standard of record keeping, to infer that this means that the model hasn't been calibrated properly because we don't have the records from these people is, with respect, just plain daft. The council's position in its capacity as local highway authority is unequivocal and has been consistent since November 2023 that it accepts the submitted information provides a comprehensive assessment of traffic and transportation impacts. The council has never advanced an objection to development on traffic and transportation grounds, save for the Warnstike issue. You'll recall, sir, that in its statement of case, the Rule 6 party refers to there being a severe and unacceptable traffic impact. In its evidence and its opening statement, it now argues a watered-down different case, referring to there being a query as to whether the effects have been correctly predicted, although its expert has sought to advance a not proven case to his satisfaction. What Mr. Russell has not done, therefore, is to explain why the supposed effects on the highway would be severe, and furthermore, since he relies upon congestion alone, what is the additional factor, i.e. additional to just mere congestion, that is being relied upon by him, which makes the effects severe? The overall impression is that rush hour traffic is already inconvenient, and the parish councils aren't prepared to countenance it becoming a little bit more inconvenient. That, of course, may be a genuinely held concern, but it emphatically isn't evidence which even approaches a severe impact. Mr. Russell's agnosticism is founded on the fact he was taken aback due to the standalone model being provided by the appellant not aligning with his observations to a very high degree. This is, of course, an argument put forward by Mr. Russell, accepting that he does not challenge the trip generation used by the appellant, does not raise issues in relation to the geometry of the proposed access, its design and layout. Similarly, Mr. Russell sought to raise no issue in relation to the proposed 106 contributions in terms of reducing reliance on private vehicles, and agreed he does not seek to identify any additional sustainability or other measures that the scheme should provide and fund. He hasn't challenged the information put forward in relation to traffic accidents, and he hasn't alleged the development would result in safety concerns either. The argument is therefore very much limited to the validation not proven case, i.e. he's not supporting his client's case that there is a positive case before you to suggest there would be severe impacts. That being said, Mr. Russell also fairly accepted in cross-examination that national policy doesn't seek to avoid further inconveniencing drivers. Mr. Pinto addressed this point during cross-examination. The policy test is not to protect commuters, and we are dealing with a key commuter corridor in Bath, and its purpose needs to be considered. It is, certainly on the AM peak, the odd down roundabout is the first roundabout into the urban realm to slow traffic and hold traffic. This road is operating in the manner it's been designed for, plus the mitigation offered will offer a level of relief. Mr. Russell hasn't provided a TA, doesn't have to. There's no positive assertion of impacts, and only assertion that what's been done is wrong insofar as the recording of data is concerned in the context of his not proven case. Mr. Russell expressly agreed that he himself cannot, in fact, conclude whether there has been appropriate mitigation or whether or not the TA properly assesses impact. He just doesn't know. But that's in the context of the Highway Authority being able to reach a conclusion, Mr. Bales being able to reach a conclusion, and the appellant being able to offer its conclusions. The only expert that's unable to do so is Mr. Russell. And yet, whilst refuting the findings of the appellant in the Local Highway Authority, he isn't actually adopting the conclusions of Mr. Bales' severe impacts. And yet, at no point since Mr. Russell's instruction in September 2024 did he seek to even discuss his concerns with officers of the Local Highway Authority, despite concerns related to calibration. This contact, had it happened, could have been sufficient in itself to address any concerns that he might have raised with officers of the Highway Authority. He could have talked them through with the Highway Authority and then could have advised his clients about the extensive checking that must have taken place. He could have sought to ask about the March 2024 memorandum, in which the Highway Authority explained why they don't share Mr. Bales' concerns in the light of the drone footage. But instead, amazingly, Mr. Russell doesn't even condescend to reporting his proof on the existence of the March 2024 Local Highway Authority memorandum. The important difference between the Local Highway Authority and Mr. Russell is, of course, that the former has duties in law to satisfy itself with regards to the severity of impacts, and whilst Mr. Russell acts on behalf of the parish council, who don't have the same duty. Importantly, it is simply not open to Mr. Russell, and rightly he didn't do so, to argue that the competing view of the Local Highway Authority isn't an informed one. And as to the use of the CCTV, Mr. Russell has criticised the calibration of the model, however seemingly limiting his criticism to saying that there's nothing wrong in principle with looking at CCTV and basing calibration upon it. And whilst expressing this criticism, he agrees that companies like Streetwise, who were used, commonly use CCTV and engage in the same exercise. No more do we have students sitting on deck chairs counting cars, apparently. His point about not having documentary support available to him to record queuing and behaviour on the CCTV presupposes that absence checking by some other third party, that it should somehow be inferred the data is questionable. Happily, in this case, whilst Mr. Russell may not be that independent party, ACOM on behalf of the authority are. So his concerns with there being no quantifiable data, presumably in vast numbers of tables produced in the inquiry, that followed such a review is that he hasn't been able to check the data, not that the data hasn't been checked. In other words, Mr. Russell might be better described as not one asserting that the calibration is deficient, it is one asserting that there aren't enough documents to show that it's not deficient. It is odd and illogical that despite Mr. Russell's protestations challenging the adequacy of the analysis put forward when using the CCTV for calibration purposes, that he knew of the existence of the CCTV footage at least as far back as March 2024, or rather his clients would have done, but he failed to request it until a week before the inquiry and doesn't press the point. His client and Mr. Bales simply haven't asked to see it. So Footnote 125 is another addition. I think it's my penultimate addition to respond to my learned friend's closing. So I will read this if I may. So, sir, footnote 125. Paragraph 57 of Mr. Neal's closing is wholly mistaken. There is no contradiction between Mr. Pinto's proof at paragraph 367. I think my learned friend's closing has a typo because he says it's 337. He means 367. But there's no contradiction between that part of Mr. Pinto's proof and Mr. Pinto's rebuttal at paragraph 214. 367 needs to be read in context, particularly read on and read to paragraph 374, which explains that because there are serious shortcomings with just validating against queue length, what actually counts, as TRL say, is whether the junction is working as predicted. That is what paragraph 374 says, and this was a key part of the actual calibration exercise by Tetra Tech and AECOM and presumably the local highway authority. Doesn't mean that queuing is ignored, but there's a caution here to apply, as it's not easy to tell the difference between slowed traffic, i.e. traffic not queuing, and slow traffic, which is going slow enough that it is queuing. That was the purpose of the cross-examination put to Mr. Russell in cross-examination, referenced by my learned friend at paragraph 43. And with respect, fantastic jury points that he makes, with respect to his point, it didn't badly backfire, demonstrating that queuing is restricted. Rather, it demonstrated that queuing is restricted to the peak hour only, and that the roundabouts themselves work during that period. That's the paragraph 374 point, and that even on the video, what is actually queued and what is slow moving is still a matter of judgment, which is the paragraph 368, I should say, sir. So it's the point that follows on from paragraph 367. Mr. Russell's evidence that what is needed is a lot of tables, which is what my learned friend I assume means by extrapolation and what Mr. Russell meant by quantification, to calibrate a model. You need lots of tables to calibrate the model, grossly underestimates the sophistication of both what should be done and what actually has been done in this case, which is to see if the roundabout works. So reverting back to text, if I may, paragraph 170. Whilst having failed to request it, Mr. Russell nonetheless maintains that despite the fact that the Highway Authority hasn't requested it and that Tetra Tech haven't done it, that there should have been quantification in place which would have allowed him to scrutinise the evidence to his satisfaction. And despite that objection being at the heart of the Rule 6 parties case, when asked about the actual reason behind the CCTV calibration being unacceptable, it seemed that this, in fact, is limited to Mr. Russell expressing that he wouldn't have done it like that. Indeed, during cross-examination, Mr. Russell had just stopped short of suggesting that the Highway Authority may not have visited the A367 when formulating their views. When asked about the weight that the views of the local Highway Authority attracts, having spent hours looking at this roundabout and the information presented to it by Tetra Tech, Mr. Russell kindly suggested, in fact, the views of all the witnesses are important and that his views are just as important as that of the local Highway Authority. Mr. Russell also confirmed that his argument in respect to the need for a microsimulation model as opposed to the Junction 9 model hinges upon him taking issue with calibration. In other words, that if he, Mr. Russell, had it performed to his satisfaction, the Junction 9 model would have been sufficient, and agreed that if, sir, you are not with him on calibration and find the Junction model is fit for purpose, the use of an alternative microsimulation model would just be a matter of preference. And the point made by the Rule 6 party in respect of queues and what amounts to queues is with respect neither here nor there. The issue is whether there are severe impacts. The appellant produced and relied upon TRL, that should be, sir, forgive me, Transport Research Laboratory, note PPP 2224, which illustrates that when understanding what's meant by slowly moving traffic rather than slow traffic, one has to form a judgment. In the extract put forward, the assumed speed of traffic was taken at 5 kph for all queues in that instance. Mr. Russell's agreed that when reviewing the drone footage, equally a judgment needs to be formed in the circumstance of this case as to whether traffic was slow or slowed. Mr. Russell agreed these analyses and confirmed the factors listed in his rebuttal proof are legitimate factors to be taken into account in this respect. As such, that's the rebuttal proof, Mr. Pinto, obviously. As such, it's clear on the evidence that the difference between Mr. Russell and Mr. Pinto appears to be a matter of difference of professional opinion when looking at queuing and nothing more. In this context, it's clear that the issue raised by the Rule 6 party on queuing is a bad point. Mr. Pinto's evidence is clear. Queues can include traffic that's moving. Mr. Pinto clarified further that he consider queues to be formed when traffic is moving at around less than 3 miles an hour, in other words, a rolling queue. So it all comes down to a spectacularly simple criticism on the part of Mr. Russell. Mr. Russell thinks that the drone footage shows what's properly described as queuing, which he thinks is well in excess of what Mr. Pinto's assessed. Whereas Mr. Pinto's position is he takes a fundamentally different view of the drone footage, that it shows the vehicles have been slowed on their approach into Bath, but the number of vehicles that would properly be described as queuing is comparatively small. But critically, the drone footage shows at all times the roundabouts working as one would expect them to at a peak hour. The sense check is to see what Mr. Bales makes of all this. When he modelled on the basis of the assessment on the drone information, Mr. Russell was patiently taken by me through Mr. Bales' table in cross-examination. Yes, they showed delay and some increase in delay with the proposed development when compared to Mr. Pinto's work, but nothing like the vast differences that Mr. Russell has based his professional astonishment upon. The fact that Mr. Russell hasn't done any like-for-like analysis and quantified his aerial CCTV into tables and fed that into a model as Mr. Bales has done, adding in the effect for the crossing being called north of the odd down roundabout, doesn't mean that Mr. Bales' work isn't an effective sense check of Mr. Russell's professional disbelief. Rather, what it actually shows is the position of the local highway authority was right after all. And finally, sir, I say this on instructions. Had this highway case been run by the council, it would have resulted in a costs application. However, it's recognised that this is a third-party issue coming from a genuinely held perspective of scepticism from the parish councils. So whilst it remains the view of the appellant that this has not been a reasonable approach to be taken in respect of this issue, and despite the unnecessary expenditure which has arisen, it is not considered that the additional exceptional circumstances to make a partial application for costs against a third party have been made out, and so you won't hear one from me. However, notwithstanding all those points, sir, they are thoroughly bad points, and this point takes us nowhere. So I then deal with a number of issues which I don't propose to read out, sir. I deal with the issue of ecology and reliance upon Ms Jenkins and Dr Duverger, paragraph 181 to 183. In respect of lighting, sir, I deal with Ms B, who addresses matters from 184 through to 187. Again, sir, unless you wish me to do so, I don't propose to read those out. In respect of flood risk, sir, I set out the position of Ms Hunt at 188. And then in relation to master plan, sir, I do just want to pick out a couple of points in relation to this, but not many. So, sir, this is a point that you'll recall that Mr Waters and I crossed swords in relation to them. 191, there's a common statement of common ground as between the council and the appellant in relation to that. And, sir, it's worth highlighting these points in this regard. As between ourselves and the council, sir, the submitted master plan has been prepared based upon an appropriate analysis of the site and its setting, as well as constraints and opportunities. It's comprehensive in its spatial extent, and it relates to the entire strategic allocation. 2, it's agreed the level of information provided on the comprehensive master plan is commensurate with the hybrid nature of the application. It's agreed the submitted master plan and supporting documents are sufficiently detailed to provide an overall appropriate guidance for the development of the whole application, and is therefore considered to be sufficiently comprehensive by the council and the appellant, both in terms of its spatial extent and level of detail, and complies with placemaking principle number 2. So I then address a couple of the points in relation to the master plan and Mr Waters, but I come to the conclusion at 197 that I invite you to conclude, sir, there is simply no substance to this argument, which is frankly a very loud so what point. And then finally, sir, in relation to planning balance, so there are a variety of benefits, and this is literally taken from the opening submission. So I'm going to read these out in summary rather than read them out in full, unless you wish me to do so, sir. So the first one is the contribution of new homes. The second one, sir, being affordable homes at 40%, which, sir, is the one that's in bold, double underlined. The next, sir, is the issue of economic benefits. The next, sir, is the recreational benefits. The next, sir, are the biodiversity net gains. The next is the increase in capacity towards primary health care at the local surgery. The next is the substantial contribution to sustainable transport measures, more than £500,000. The next, sir, are the heritage benefits which arise from the crossing of the Wansdyke. Yes, there's an impact on its setting, but there's also the protection of its substance, sir, by imposing the crossing. And so you will have seen the extent of erosion. And so bringing all that together, our position is that the public benefits clearly outweigh any impact with regard to impact on heritage assets, designated and undesignated. So in conclusion, paragraph 207. Finally, it will have become evident during the course of this inquiry that this is not an allocation which is locally popular. There have been consistent opposition to its release from a number of quarters. Officers are to be commended for having assessed the application dispassionately and presenting a balanced and well-reasoned report, and I should add update. It is telling that there has been little, if any, criticism of that report during the course of the inquiry, but a good deal of reliance upon it. Its content, sir, is strongly commended to you as powerful reasons as to why this appeal should be allowed, notwithstanding our submissions. It's also acknowledged that the one real remaining reason for refusal rests upon judgments, and that the councillors have been able to secure the services of a landscape architect to support their view, albeit that the reason for refusal argued that exceptional circumstances weren't made out, whilst their witness has contended that it would be for a scheme of 150 units. Accordingly, despite the profound frustration of the appellants, there won't be an application for costs at the end of today, sir, and that's not because we think that the councillors' conduct has been reasonable, far from it. Rather, it's because the appellant is committed to seeking to bring forward this latest extension to the city in a manner consistent with good design principles, and seeks to work with the council and the parish council moving the scheme forward. Overall, sir, forgive me, sir, before I turn to 208, I ought to just flag at one point, this is a response to Mr. Morgan's closing submission, which is footnote 146. So paragraph 5 of Mr. Morgan's closing submission, he contends the tilted balance isn't engaged. With respect, he omits that if his own officers in the officer's report, and particularly the update, writes to have concluded that the proposals conform with policy B3A, and as officers did conclude that there's consistency with the development plan taken as a whole, therefore paragraph 11C of MPPF would be engaged, and so the presumption in favour of sustainable development in paragraph 11 would be engaged. So not the tilted balance, but the presumption overall is engaged, sir. And that's a point I should have flagged up in 207. So reverting back to text, sir, paragraph 208. Overall, this is a good scheme, which should have been consented long ago. In view of the above analysis, sir, the weighing of the significant benefits and given the suitable mitigation of the development impacts, we, of course, sir, respectfully invite you to allow the appeal. So unless I can assist you further, those are our submissions in closing.
Thank you, Mr. Tucker.
Thank you,
just
sir.
had a couple of points of clarification earlier on in your submissions. I think that these are just errors in terms of numbering, but paragraph 87, you talk about the demise. This is to do with replacement planting being agreed with the council, obviously. You refer to a reason for refusal number 2. I assume that
should be 4.
4, yeah.
Yes, sorry, sir.
Thank you. And then a couple of paragraphs later, you refer to the GI parameters plan CDJ3, which I think is an earlier version. I think it's now R14 is the correct version of that plan.
So I'll check that and perhaps revert back before you formally close the inquiry, if I may, or others may do so, having heard that. But that sounds right, so forgive me.
I think that should be right, because I think that is an earlier version. But yeah, let me know if I've got that wrong.
Yes, sir.
Otherwise, thank you for delivering those closing submissions for the appellant.
Thank you, sir.
So I think then, unless just make a note of the time. So I think, yes, we just want to probably finish with a few points regarding conditions and obligations. Any updates on that before we do any final housekeeping points? So I don't know whether Mr. Frampton and Mr. Griggs-Trevelyan have had an opportunity to talk about those conditions, the building heights condition and the phasing plan condition, and anything either Mr. Frampton or Mr. Griggs-Trevelyan wants to say.
Yes, indeed, sir. There has been an exchange between myself and Mr. Griggs-Trevelyan. What my office has done through Miss Fraser this afternoon is to issue an updated list of conditions that picks up the points that we discussed this morning on the lighting condition, which is now condition 8, to avoid 2 condition 4s, and the phasing plan, which is now condition 12. Regretfully, there isn't white smoke on a building heights condition. I've revised the wording. You'll see from the appellant's perspective, if you conclude that the 3-storey height of 40 metres is not acceptable, Mr. Trevarthen, who will no doubt speak to the council suggestion, and that's to leave the actual heights for you to make a judgment in imposing such a condition. So the 2 conditions are set out on that final schedule. And I've also issued, I believe has been issued, I've asked for confirmation, yes, it has been, an email to you confirming the appellant's agreement to pre-commencement conditions that we discussed. And if you conclude what I've called the one-site condition is justified on a pre-commencement basis, the appellant would agree to that also.
Thank you, Mr. Frampton. On that last point, I think the requirement for pre-commencement conditions that doesn't apply to outline elements of a scheme. So whilst I note what you said there, technically your client's written agreement is not needed for that one-site condition, but thank you for that clarification on the other conditions. In terms of the council's position, Mr. Griggs-Trevarthen, anything you want to say on what Mr. Frampton has just said?
No, sir, not really. I mean, he has fairly articulated the position that the 2 parties have reached. You'll see the comments on the building heights parameters plan condition that we've put, and all the other changes that have been put forward are those that were discussed and suggested this morning. So nothing further to add, sir.
Thank you. So essentially, I've got 2 versions of that building heights condition for me to sort of consider.
That's correct, sir.
Okay. Thank you for that. Well, I'll keep an eye out for that updated conditions schedule. Unless there's anything else on conditions, I think we'll leave it there. Thank you both for that update. In terms of the 106, I don't know if Ms. Fraser is here, but I don't know if any discussion has been had on that paragraph. I think it was 16 in part 4C, and Mr. Frampton, you may be able to help.
So I was just coming back to conditions, the 2 correspondences. Do you wish to give those ID numbers just to assist Ms. Fraser?
Happy for them to be added. Yes.
Yes, thank you.
Is that the pre-commencement conditions and the updated schedule, presumably?
Yes, indeed. Thank
they
you.
Can be added as the final, but whatever the final numbers are.
And all I've had during the sort of closing of Mr. Tucker is an email to say that the clause 16 of the section 106 is agreed, and in fact the section 106 is agreed in its entirety. Okay, so has that clause 16 been updated then? Presumably? Yes, that's my understanding. Okay, and agreed. Obviously, Mr. Griggs-Trevarthen, is that yourself?
Yes, I've seen that updated. Sorry, sir. I've seen that updated clause, and I'm happy to agree that one.
Out of interest, what did it say?
It was. Well, I don't know if Ms. Frampton can summarise it better than me, but it essentially inserted a time frame of oh God, was it 3 months? Sorry, Mr. Frampton might know off the top of his head.
I can't actually. I've just been told that it's agreed. So I don't know if I might receive a WhatsApp very quickly. I'll be able to update you, but I don't have that information.
So might I suggest the easy way will be for us to ask Ms. Forbes to just send a quick note to the case officer to explain exactly what the text is, and to do that by close of play, rather than necessarily putting the burden on the 2 planners.
That's fine. I appreciate Ms. Forbes isn't here actually. Sorry, I was getting confused.
I've just checked it to use reasonable endeavours to reach agreement within 3 months. So there's the right. But yes, a note would be helpful, I think.
Okay, I'm happy to have that note just to understand. And obviously, because I assume the next time I'll see the 106 will be in an executed form. So obviously, if something in that note causes me concern, I'll obviously need to flag it up quickly so you know of any changes that might need to be made. Thank you to that. So thank you. So I'll look out for that note later on. But I don't think that requires me to keep the inquiry open, I think we can still close this afternoon. Obviously, if there's any issues with the 106, I'm sure that can be addressed separately. Thank you. So anything else on conditions or the obligations from anyone? If not, then obviously just in terms of the Mr. Tucker's already indicated no cost applications from the appellant, so thank you for that. I assume that is it on your cost case. You're not arguing any costs, Mr. Tucker.
No, sir, there's no application in any respect from me, either from the withdrawal, the reasons for refusal, the points I made on highways, nor overall, sir. Thank you.
Okay, thank you. Mr. Morgan, anything from the council in terms of costs?
No application, excuse me, no application for costs from us, no.
Thank you. Mr. Neil, anything from the Rule 6 party?
No, sir, the Rule 6 party isn't making a cost application.
Okay, thank you. So just in terms of then final documentation and so on, I think we said this morning about the transcript being added as an inquiry document. I'm happy for that to be done. Obviously, I don't know how well the transcript picks up on what's said, so clearly it may be not as clear as a word for word transcript style in another form, but obviously if that's added, then we have that as the record for avoidance of doubt. I don't know, I tried to click on the recording link, because I think if you're using, depending on what version of Teams you're using, I saw there was a link to the recording in the chat effectively for this. Not that anyone can actually chat, but when I clicked on it, it seemed to take me through to a password only page on the council's website, I think. So there might be a need for some kind of access to that, Mr. Griggs-Trevell, just to really need to double check that people can see that recording.
We'll look into that, sir, and sort out whatever needs to be done. Yeah,
I don't know whether that recording will be uploaded onto the council's website or just available through Teams, but if you could just clarify.
Yeah, we'll figure out what the options are. I imagine it might be uploaded to the council YouTube channel. It's probably the most sensible, but we'll report back to you, sir.
Okay, thank you. Just to know where it is. Thank you. And I think we've had about 30 or so people watching via the attendees only section, so I think it has been useful to have that option. So thank you to the council for providing that. Then in terms of the obviously any final documents that need to be added to the webpage, please ensure that is done in terms of conditions and so on. And I assume that can be kept open until at least the decision is issued. Obviously, it's the appellant hosting it, but Mr. Tucker, I assume that's okay.
The answer is yes. Not only can it will be, and so it will be retained until such time as how can I put it? Until it needs to be closed down. So it won't be closed down in advance.
No, okay, I understand. Thank you very much. So any final procedural queries from anybody in the course? Anything from the appellant, Mr. Tucker?
Nothing from me, sir. I'll just double check the WhatsApp. No, there's nothing.
Oh, and sorry, that point on that core document, that GI document. I don't know if you have anything on the WhatsApp, but I'm pretty certain it's R14 rather than J3. But
so knowing how careful my colleague Miss Jackson is, that had it been the wrong one, I would have been told pretty much immediately. Okay, well, so work on the assumption that your note is correct.
Okay, fine. Well, yeah, no news is good news on that.
Yes, sir.
Thank you. So nothing else from the appellant?
No, sir. Thank you.
Thank you, Mr. Morgan. Anything else from the council?
No, other than to thank the appellant for hosting the core documents. Thank you, and looking after us in that way. I'm grateful to them.
Yep, that's okay by me too. So thank you to the appellant for that, and thank you also to the council for obviously hosting the event in person in Bath, and obviously today as well. It's been very much appreciated. Thank you, Mr. Morgan. Anything from the Rule 6 party, Mr. Neil?
No, so just to echo your thanks to the local authority for hosting the inquiry over the last 2 to 3 weeks.
Thank you. Anything from anybody else? If not, then I'll just obviously my decision will be issued as soon as possible, and obviously all parties will be notified of that when it is issued. Thank you all for your efforts. I'll keep an eye out for the remaining documents in 106 over the next couple of weeks, and obviously update me on anything that needs to be updated on in terms of anything to do with the inquiry. Thank you all. We'll bring this to a close now, and I wish you all a good rest of the day. So the inquiry is now closed. Thank you.
Thank you, sir.
Thank you, sir.
Thank you very
Goodbye.
much. Bye, everyone.
Take care. Thank you.
Cheers.
Yeah, we'll get our own meeting now. See you.